Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends, and welcome. Today is Tuesday, March 3rd, 2026. How's everybody doing today? It's already March. And I heard the coldest weather of the year is behind us, but who knows if that's even true. Is it true? I don't know. We're going to Ohio today. To cover the case of Ruth Miller. In the show notes below is a very extensive summary of this case. Some of you may remember it. There's also a clip that you can click on to the link of the body cam footage that we looked at probably in September, I think. And you may recall this, right? The fish in the water. Yes. This is a horrific, tragic story of religious delusion, spiritual delusion, and murder involving a mother, an Amish mother in Ohio, who was on vacation with her family all the way back in August at a place called Atwood Lake in Ohio. And do you remember the very horrific body cam that we watched? This is going to be really interesting to watch today because we're going to see the difference between the way an Ohio court treats a person who is clearly mentally ill, at least from what we saw in the body cam footage, right? And the way a Massachusetts court is handling the same situation in a case like LINDSAY CLANCY. So this involves a mom who took the life of her 4-year-old son, saying that she was giving him to God. Remember the body cam footage? It was horrific and scary. 10 a.m. there's going to be a bench trial. This is so interesting to me because this crime happened 6 months ago. Remember, the husband also died, but apparently he drowned himself trying to walk on water. And then the mom, Ruth Miller, took the 4-year-old, gave him to God by drowning him in the lake. And then later on, she took her 3 teenagers in a golf cart, tried to drive the golf cart into the water, but luckily the 3 teenagers were able to survive and they saved themselves. And the body cam footage, the police did so well dealing with her. The body cam footage is chilling. 1 week ago, Ruth Miller, who's been in custody ever since, she's only 40 years old. She looks a little bit older. No shade, but she looks a little bit older. 1 week ago, she waived her right to a jury trial, and the judge agreed to give her a bench trial. 3 mental health experts, the one for the state, and I think there was one for the defense, and then maybe one that they chose together. 3 mental health experts have all agreed that she is legally not in her right mind. So she waived a jury trial. The judge took all of the police reports, all of the evidence with regard to this case, including the mental health expert reports. He has reviewed them over the past week, and he says that he's going to give his verdict today at 10 a.m. This kind of flew under the radar. And what's so interesting about this to me, there's no witnesses are going to be called. No witnesses are going to be called. So this was only 6 months ago. And this judge is going to enter a verdict today at 10 a.m. We're going to go for the verdict, but he's also going to give the attorneys an opportunity to speak before he does so. And what I find so wild about this is the difference in the way that this woman is being treated in Ohio, and the way that LINDSAY CLANCY is being treated in Massachusetts. LINDSAY CLANCY's been in custody for something like 3 years or more than 3 years, and she's been held in a mental hospital in Bridgewater State in Massachusetts. For those of you who've been watching the case with me, what I want to do is the difference also between Massachusetts and Ohio with regard to a not guilty by reason of insanity plea. Let me pull up my notes here because I did a little research for you on this morning. If a defendant pleads guilty, not reason by please guilty by not guilty by reason of not guilty by reason of insanity. In Massachusetts, the burden shifts to the Commonwealth for the Commonwealth to prove that the defendant was sane at the time of the crime. And the Massachusetts prosecution must prove beyond a reasonable doubt that the defendant was sane at the time of the crime. In Ohio, the defendant has to prove that they were insane at the time of the crime, but they only have to prove it by a preponderance of the evidence, which is the civil standard. It's just if you have the scales of justice, you just have to tip it one way. And the defendant has to prove that they were insane or didn't know what they were doing, didn't know right from wrong at the time of the crime. It's night and day. Every state has its own rules with regard to not guilty by reason of insanity, and some states don't allow it at all. There are 4 states that don't allow it at all. Utah, I forget what the other 3 are off the top of my head. Let's go back to what happened February 24th and listen to a local news piece about what happened in court that day. And that was the day that Ruth Miller, thanks Karen, that Ruth Miller decided to waive her right to a jury trial. And then this same station, Channel 19 or Channel 3, is going to be broadcasting what happens in court today live. So we're gonna pivot to that as soon as it comes on. It's going to be very interesting. I saw Lindsay's hearing yesterday, but what had happened was, as I watched it live on YouTube, as soon as it was done, they took it away from YouTube. If I can find it on YouTube, we can play that also to compare. But let's
Miller has just
this is from, again, February 24th.
19 News coming to you from our digital desk. I want to take you live to Tuscarawas Court. Ruth Miller has just been seated there. Ruth Miller is the mother on trial, facing murder charges of her own 4-year-old son. You'll remember this from Tuscarawas County from last August. The husband and father had gone to Atwood Lake on some sort of religious pilgrimage with their family. They were questioning their faith. They are Amish, and the father and mother put themselves through a number of trials, is what they told investigators, to try and test their faith in God. For one, they tried to walk on water. That obviously didn't work, and it supposedly, to Ruth Miller, proved that they weren't being faithful. She then
here's the other thing, is that the husband didn't tell them anything, because the husband was also found dead at the bottom of the lake by the divers. So I'm not sure what he meant by that.
Crew is accused of throwing her 4-year-old son in the lake. He would drown. The husband drowned trying to swim himself in one of his challenges. This is a pre-trial hearing, so let's take you live into court.
I was scheduled final pre-trial to meet with lawyers, to find out from them as to what has been taking place, and most importantly, how they anticipate that we are going to be proceeding.
Is the volume on this okay, or do you need to boost it a little bit?
In these matters. Ruth, they tell me that this is a case in which I should anticipate that this is going to be going in the way of a bench trial, which would mean I would be deciding the outcome as opposed to a jury. Right to a jury trial is a fundamental constitutional right that everyone would have in a felony case. So to get to that point of having a bench trial, it would require that we have a dialogue about waiving of that constitutional right. But before I launch into that discussion about waiving that right, I think it's best that I hear from the lawyers in this case to make sure.
All right. Some people say it's good. Some people say it needs to be boosted. The problem is that the booster makes it a little bit fuzzy. I mean, a little bit distorted. So I'm going to leave it like this for now.
I'm on the right page, and if I am, then we'll have that discussion. Ruth, I'm going to start with your side here first, and then I'll hear from this side of the room next as to what their expectations are. So, Ian, Madeline, whoever wishes.
Thank you, Your Honor. Good afternoon. Your Honor, you are correct. There would be a waiver today making this proceeding a bench trial in response to what has been stipulated to by the parties and is being admitted to you for your consideration. That is a list of 5 exhibits which the state is providing to you. Exhibit 1, mostly made up of that discovery, police reports and the like. And then exhibits 2 through 4 are the mental status evaluations. The first by District 9, that which you called for and was performed by Dr. Hrinko, Hrinko. The report from Dr. Hatters, Hatters -Friedman, Friedman. There is no relation, just to be clear. And then third, the mental health evaluation by the expert, Dr. Merritt, Marett, that was engaged by the state of Ohio. Those 3 reports all concluded and opined that Ruth Miller was not guilty by reason of insanity at the time of the conduct in this case and could not appreciate the wrongfulness of her conduct at that time.
Do you know how rare that is? Do you know how rare that is that 3 experts, a court-appointed expert, a state-chosen expert, and a defense-chosen expert all agree that the defendant is not guilty by reason of insanity? I want to tell you that in Ohio, as I looked up before, the success of a not guilty by reason of insanity plea is it's 1/4%, the amount of successful not guilty by reason of insanity pleas in Ohio. It is so rare. Oh, hi, Dr. Patrice Berry. How are you? Dr. Patrice Berry, who also has a YouTube channel, go out and give her a sub and a like. She's awesome. Says it really is rare. The body cam footage made it clear, in my opinion. Yeah. Clearly, she had some sort of psychotic break. You can opine better than I because I'm not a mental health expert, but I'm here to tell you legally how rare that is.
Parties agreed to and stipulate to the authenticity of the reports, the content therein, and to the findings. And so we bring that to your attention along with Exhibit 5, which is a zip drive containing statements that were made by Ruth Miller to Captain Fisher in the date in question, the date of the incident. It is our expectation as we go forward. Attorney Grant and I, at this point, are not calling certain witnesses for the bench trial, as we'll be relying upon your evaluation of the records that are being submitted to you.
Also, incredibly rare No witnesses are going to be called. The judge is going to rely on her statements at the scene, which was the body cam footage that we watched. That's also linked in the show notes below. And the medical reports and the police reports, incredibly rare. This crime was only 6 months ago.
That if you accept the stipulation by the parties at the hearing that Ruth Miller was in fact, and just for brevity's sake, NGRI at the time, we would then move on to placement hearing at the time that Your Honor sets. So
Also, I cannot stress to you how incredibly rare this is, that the state would agree with the defense. They stipulated that she is indeed not guilty by reason of insanity. And that the only really thing for the judge to decide is whether he's going to accept that stipulation and where they're going to put her. Placement so fast, within 6 months.
All those reasons and for the findings that are contained in it, it was unanimous. There were no experts that opined differently. Because of that, the defense at this point is going to rely upon presentation-wise for the bench trial to that which is being submitted to you all. Thank you.
Thank you. Brett, on behalf of the state.
Yes, Your Honor. Mr. Friedman did accurately depict our discussions. As you know, I've taken over the case for Mr. Steyer, who's going to be taking the bench across the hall in a couple days. I did put together a list of the police reports that I believe, most of the supplements that I believe describe the conduct, so that you have information to make a determination that Ms. Miller did indeed commit the acts with which she's accused. And that's about 42 pages. And then there are 3 mental status evaluations. One obviously conducted by the court's psychiatrist, one then conducted by the defense psychiatrist, and then one conducted by a psychiatrist hired by the state of Ohio. Given the findings, as all 3 opined for various reasons, that Ms. Miller did not appreciate the wrongfulness of her conduct and was suffering from this severe mental illness or defect at the time of the offense. Given that, we have decided to submit this case to you for a non-jury trial, for you to review those matters and make an appropriate finding. And as he indicated, I've also included a zip drive containing the 2 interviews that Ms. Miller gave to Captain Fisher, the TUSCARAWAS County Sheriff's Department. So we are in agreement that there's a stipulation as to the authenticity and the admissibility of all these documents, I believe. And with that stipulation, we would not plan on submitting any other evidence next week or at whatever the trial date is. And we would just rest and wait for your conclusion.
Okay. All right, with that recitation then, Ruth, let me tell you what I believe, what I anticipate as far as how this case will proceed, and then I'll have a discussion with you so that you know how this matter is proceeding before you waive any type of fundamental right. So what they've said to me is that, and what I think they are anticipating is that there are 5 exhibits that they want me to consider, a couple of police reports and 3 expert reports. One that I ordered, which I've already seen, one that you had acquired through your counsel that I have not read, and the report that was generated by the state that I have not read. And I don't know how long they are, but I know they're going to take a little bit of time to review, along with a lengthy police report. My expectation is that they want me to consider those, read through those. I'm not going to be admitting them. Today is not the trial, but they're essentially giving them to me as a preview to look at. We would then come back next week to conduct what I've referred to as a bench trial. It is a non-jury trial, as the state has called it. Bottom line is, there wouldn't be 12 people sitting in those chairs over there listening to evidence, listening to argument of counsel. It would be decided by me, and it would be decided based upon those 5 exhibits that I'm going to be receiving from the attorneys in this case. Ruth, you have an absolute right to have this matter decided by 12 citizens. The way that would work is that the room would be filled up 50, 75 people.
This is interesting. He's giving her a colloquy so that she understands that she's giving up her right to a jury trial, which is a right under the U.S. such U.S. Constitution. And he called her Ruth. And he also doesn't wear a robe, just like Lisa Lott in Georgia. I think a jury could find her guilty too. I think so too, Dr. Patrice. Listen to that again. He's wearing a black suit with a white shirt and a gray tie for those of you who can't look at your screen right now, but he called her Ruth. Listen to this.
Bottom line is, Ruth, there wouldn't be 12 people sitting in those chairs over there listening to evidence, listening to argument of counsel. It would be decided by me, and it would be decided based upon those 5 exhibits that I'm going to be receiving from the attorneys in this case. Ruth, you have an absolute right to have this matter decided by 12 citizens. The way that would work is that the room would be filled up 50, 75 people. And from those people, we would pick 12 that would sit over there in those chairs. And your attorney and the state's counsel would have the opportunity to inquire of those 12 people to find out whether they can be fair and impartial. And ultimately, after going through however many people we have here, the court and counsel settled upon 12. And those 12 would listen, and at the end of the case, they would be given the opportunity to deliberate or go off in a separate room and consider what they've heard. It would require all 12 of those individuals to be unanimous in their opinion that you were guilty before you could be found guilty in this case.
Galaxy, no one's lashing out at the judge. I think we're just comparing it to Georgia, where we just covered a whole trial with another judge who didn't wear a robe either, and we kind of thought it was odd. I like my judges to wear robes. I just feel like it's more formal.
That's an absolute right that you have. But we all have constitutional rights, and we all can waive those constitutional rights. The key is that we make that decision knowingly, intelligently, and voluntarily. Ruth, have you had an opportunity to discuss this matter? And I'm not interested in what was said. I'm just interested in knowing, did you have a full and fair opportunity to discuss that matter with your attorneys? I just need you to answer out loud.
Yes.
Okay. And you feel as if all of your questions and any concerns you may have with that right were answered by your attorneys?
Yes.
And you have confidence in their representation and any advice that they have given to you?
Yes.
Okay. Do you understand that, Ruth, that I'm asking you at this time if it is your intention to give up that right to having the matter decided by that jury of 12 individuals? Okay. And is it your intention to waive that right to have the case decided by a jury? Okay. Then, Ruth, I'm going to provide you with this form. It's just reflecting what we have discussed here today. I want you to take a moment if you need to discuss the matter further with your attorney to make sure that you have all your questions answered. All right, the record should reflect then that the waiver of right to jury was signed by Ruth Miller here in court. And she indicates I, Ruth Miller, defendant in the above reference case, hereby voluntarily waive my constitutional right to trial by jury on the felony criminal charges contained in the indictment in this case, and consent to the trial of the criminal charges to Judge Michael J. Ernest, and I have not enforced or in any way coerced in the exercise of this waiver. And then just to confirm, Ruth, you signed this document, correct?
Yes.
Okay. Then I'm going to accept that waiver of the right to trial by jury. And we already have a date that is set for next Tuesday. I apologize, I don't have it signed.
It's March 3rd at 10.
Thank you. March 3rd at 10, set for a status conference. And that's the date we were going to utilize now for the bench trial, correct?
Correct, Your Honor.
All right. Then what will happen is, Brett, if you can provide me with that, the exhibits that we want you to consider for the ruling bench trial.
Your Honor, if I may inquire, so we're to expect that day of verdict from you
Exactly.
on that day, so
Absolutely.
Tuesday.
That is the reason that and for everyone, I want to make sure that I read all of the pages that we have here, and it's simply not going to work. We all sit around and watch Judge Ernest read this for the next 2-3 hours. So I want to be able to have the opportunity to actually read through it, and I intend to then issue the verdict on that day after hearing further from anything the attorneys wish to make as far as arguments or to be heard. I'm not trying to cut off any other evidence if there is something else you want me to consider, but it's my understanding that both parties simply want me to consider these 5 exhibits and would be stipulating to those at the time of the bench trial.
On behalf of Ms. Miller, that is correct, Your Honor.
Correct.
Yes, sir.
So that's what I'm anticipating too. It's just that I want to actually be able to read through these in my chambers and not rush through this and get a full understanding of what's in here, because like I said at the outset, I have not seen what your expert has generated or what the state of Ohio has generated in this case. I heard what they said, so it's not going to be a surprise as far as the conclusion. I heard Attorney Friedman, so I'm anticipating where this is going, but I want to actually read it. Understood? Do you have any questions for me, Ruth? Okay. Counsel, some questions?
No, thank you for your clarity.
Okay. Fred?
No, Your Honor.
All right. Then we will see everyone back here in approximately a week for that bench trial. Thank you.
Thank you, Your Honor.
Dan DeRose with 19 News here as we see the attorneys for Ruth Miller giving an explanation for what just happened. And I want to be cautious here because while I've covered a lot of court, obviously I'm not an expert here, but after just witnessing the instructions, that were just given by the judge here, we're talking about Judge Michael Ernest. This is going to be very unique. And I just want to make sure there's nothing left here in court to be discussed. From my understanding of what we just heard in court, and as we see family members there in the courtroom, I just want to stay with this a little longer, folks, to make sure there's maybe no further explanation given by the attorneys. This is going to be very different and unlike anything we've really seen before and what we were expecting here.
I can't remember the last time I've ever seen this happen in court. Anybody? Can anybody point me to a case where a bench trial, a jury trial was waived, a bench trial was held? That's not even really going to be a bench trial. No witnesses are going to be called. The judge has all the documents. He's got 3 mental health status reports, one that he court ordered, one from the defense and one from the prosecution. He's got the police reports. He's got the body cam footage, and he's just going to render a verdict. He's going to give the attorneys the opportunity to speak today. Maybe they will, maybe they won't. It seems like they're just going to rest on their papers. They both agreed. The state and the defense have both agreed that she is indeed not guilty by reason of insanity. It's crazy, right?
Tuesday, correct? March 3rd, Tuesday, March 3rd. That's the verdict. That's the verdict.
March 3rd?
Yes, so March 3rd will be the
Today.
verdict.
Correct. He's gonna
That's the bench trial.
Yeah, he's going to.
Oh,
Oh, wait, hold on. Are they going to show more? Let's see. See if they show the body cam footage.
well, we were just getting an explanation there when our photographer cut off the shot. So I apologize for that.
Man.
So essentially, I think I've gotten very clear what is going to happen. We heard just a brief explanation there by her attorneys. Both sides have stipulated. You hear the word stipulated. That means both sides agreed. Both the defense and the state agreed. There are only 5 pieces of evidence in this case.
Okay, I think I explained all of that to you sufficiently, and now we can just move over here, waiting for the live coverage of the hearing to begin today. If we have a few minutes, maybe I'll pull the body cam footage for those of you who have not seen it. Please. Is there anybody who has not seen the body cam footage? So Ruth Miller has been held without bail at the Tuscarawas County Jail since being released by a mental health facility, which I guess she was in initially. In November, going back to November, she was ruled competent to stand trial. Following her young 4-year-old's death, Miller's family and members of the Old Order Amish Church released a statement claiming that she had been suffering from mental health challenges and that her actions do not reflect, quote, do not reflect our teachings or beliefs, but are instead a result of mental illness. Let's see if I can find the body cam footage for you real quick, because we will be able to, since the Channel 3 is broadcasting this on YouTube, we will be able to stop and pause and rewind, which, you know, is what we like to do here. Let me just see where all right, here we go. I'm going to show you the body cam footage, and this goes all the way back to August of 2025. I'm just going to trigger warn you just because this is so disturbing. And again, this was at Atwood Lake in Ohio. So let me pull this up for you here. And I may need to truncate it if the hearing begins. Oops. My computer's doing some weird stuff. I don't know what's going on. Things are flying all over the screen. Oh, isn't it like a full moon? Wasn't it a full blood moon today? I think that can explain it. Again, going back to August of 2025.
4-year-old son. Take a look. And deputies around you're going to see that they blur out a portion of the video. They're blurring out the minor daughter, the daughter that's a minor. When they first approach her, you will see her 2 18-year-old twin sons. They're holding her by the arms when deputies arrive. Again, I want to maybe give you a warning that this is tough to watch. This is a mother admitting to killing her own 4-year-old son. Take a look.
I gave him to God.
You gave him to God.
Yes.
What do you mean by that?
I threw him in the lake and I gave him to God. And people are going to.
Can you hear her speaking? She said, I threw him in the lake and I gave him to God. I'm going to see if the captions are working on this. Sometimes they do, sometimes they don't. Let me see. Oh, excuse me, it chills every time I watch it. Let me see if I can boost it a little bit.
I gave him to God.
You gave him to God.
Yes,
What do you mean by that?
I threw him in the lake and I gave him to God. And people are going to tell me I am crazy, but he is real. And he loves you. He really does love you. He loves you. And I doubted him. I doubted him so many times. But I am to tell you, he is coming soon. He is coming very soon. Prepare your hearts. The end is close. And I'm for sure supposed to tell you that he does love you. Okay?
Man, can you explain to me what happened? Would you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
And you haven't seen him
He
since?
didn't ever come back. And we went to the boat and his clothes were there. And God told me he in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish. And you will find my husband.
A fish swallowed him. And you got to go to the bottom of the lake and you will find the fish and you will find my husband.
And then you will believe. But ye of your little faith that did not believe before seeing.
Okay.
So send people down to the bottom of the lake looking for a fish.
They're so patient with her. These officers, I mean, kudos to them. This is August 23rd, 2025 at 11:40 a.m.
How old's your son that's in the lake?
4. He's sweet. I gave him to God.
Okay. 7/9/40 Central. We're out with the mother. She is advising that she threw her 4-year-old son in the lake to give him to God. Affirm.
They are there.
Look at how she's touching the officers, Scott, and any other law enforcement, retired law enforcement. They're park rangers. Oh, thank you. She's touching them. They're not cuffing her. They're not restraining her. I mean, she's confessing and they're allowing her to touch them. That's scary.
He came back to me. My husband and I both got up and came back to me.
I need to know where your husband's at.
He's at the bottom of the lake in a fish.
He's in a fish. There's no fish large enough on an Atwood to swallow your husband.
He's at the bottom of the lake.
There's no fish large enough on Atwood to swallow your husband. Are they trained in mental health crises, these park rangers? Because this is amazing to me. It's amazing to me how there were no mental health professionals who came with the North Andover Police Department to serve Kelsey Fitzsimmons with an order to take her baby away and a restraining order when they knew she was clearly had been suffering from postpartum depression. It's wild. The difference in compassion and understanding.
I thought your husband went to the front for a walk.
Yeah, and then we came to the boat, and his clothes were laying in the boat.
Okay.
Tan pants and cream shirt and flip-flops.
You have a cell phone?
So the husband's clothes were found in the boat. I guess she doesn't realize that her husband is also dead. Just want to take that back a minute. The stream still has not started for today's bench trial.
Charging up on an Atwood as well, your husband.
He's at the bottom of the lake.
Okay. I thought your husband went to the front for a walk.
Yeah, and then we came to the boat, and his clothes were laying in the boat.
Okay.
Tan pants and cream shirt and flip-flops.
Do you have a cell phone?
It's in the camper.
It's in the camper. Where's your camper at?
I think it's,
Area 3?
I think so. Yeah, it's like a tannish camper.
It's a tannish camper. You don't know what lot number it is?
No.
Because we really need to verify your husband is still with us.
Oh, okay.
Okay?
Well, he's actually just go out in the bottom of the lake.
Well, I can't go in the bottom of the lake. So
Do you have scuba divers?
Yeah, we're going to have to call divers in to go to the bottom of the lake.
Please do.
And you're saying
The best ones there are. Because this is a miracle from God. We will see. We will see.
you're saying your
Miracle
4-year-old
from
son's down there
God, we
too?
will see.
He's with God.
He's with God.
Where's his body at?
Meaning the 4-year-old son. Oh, lawyer life. If this were a black woman, how would they be acting? Really? This is your first comment ever on this channel, so I guess this is your first time here. I have an idea that you might be someone who's come in under another name, but don't try and race bait me. This is Ohio. I don't think that they would have treated a black woman any differently, but I'm not playing that game. Guide your actions accordingly. Perhaps this isn't the channel for you.
Where did you throw him in the water at?
Off of the dock that causeway.
Where the bike was today? Where the boat was?
Yeah, where the boat. I know.
When there's supposed to be one out there. I think there was one.
Does anybody have a glass of water?
We can get you water.
Okay. Please.
What's up?
Thank you.
We're right now we're gonna walk up to the squad, okay? That's what we're going to do. We're gonna put you in the back of the squad.
You will find my husband.
Okay, but you wanna sit down in the back of the squad for us, okay?
Can I actually just sit with my children and have water?
Yeah, we can bring your children over.
I would love a glass of water. Let's go.
This is wild to me because she just killed one of her children, but they're going to allow her to now go sit with her other children. And Teresa says, seems like she's giving the Jonah and the whale story from the Bible. Yeah. Huh.
In this one over here. We'll bring them over in a minute. Let me go check you out. Yeah, we're gonna get it. Kyle wants to go get you one.
You guys send the dive team over that way then?
Yeah, we're supposed to bring one in.
Which dock is that so I can tell my dispatch?
That's cluster dock, the center cluster dock.
The center
Or
cluster.
on the causeway. Causeway center.
Causeway center cluster dock. 7940 Central. You said that's the Causeway Center dock, right?
Causeway center.
Causeway Center dock. 7940 Central. The mother is advising that her boat is located if you just want to walk at the Causeway Center dock, and that's where she threw the child in the water. She's also now saying that the husband's in the water. She's going to walk that and notify the dive team. The Rangers are heading over that way right now.
One juror matters pointing out that park rangers have the same legal rights as state police law enforcement. Some states allow park rangers or park police and campus police have even more power than other law enforcement. And he says that from experience. Thank you for that.
gotta go somewhere where it's not too hard on my knee. So your knee won't hurt you. Please trust me. It won't hurt you. It won't hurt you. You're fine. You're fine. Okay. God, please show this woman.
And now this other woman is praying with her. Is she part of the park police too? Is she part of an EMT crew? Can anybody tell me what this woman in the white sweatshirt and black pants' role is? She just pulled up in a camper. Okay, hold on.
You gotta go somewhere where it's not too hard on my knee. So your knee won't hurt you. Please trust me. It won't hurt you. It won't hurt you. You're fine. You're fine. Okay. God.
Yeah, I see a paramedic van there, so I think she's part of the EMT team. Yeah, paramedic, EMT team. Thank you guys for paying attention when I get to
please show this woman. It is true what I'm telling. People are doubting. They are getting harder from the stage now. Please show that it is true what I'm telling you. That there is a fish in the bottom of the lake. Please let her take me to sit with my children under the tree that you have created. Please, Lord.
You guys want to bring her over to that one?
Yeah, we'll take her over that one.
So we can be closer to the rest of the video.
All right, have a seat right here. We'll go get your children as soon as they're done. No, I want to go to them right here.
What are the kids saying now?
I don't know if they've asked if there's any brother and dad or not.
Okay.
That's it.
And their answers are true. At least we doubted too, but they are true. They are. It's okay. You tell me. Do you remember when Jesus was on the cross?
Yeah, I remember.
And he put his arms out and he said, "Forgive them, for they know not
Yeah,
what
you
they
told me
do."
that already.
Yes. They didn't know. They didn't.
Forgive them because they know not what they do. They're blurring out this part because her minor daughter was in the shot, and that's the right thing to do. Lady MD, lady doctor, 63. These law enforcement folks come from communities where basic human rights and values are important. They know she's mentally ill, and letting things get out of control isn't going to help, she says.
Didn't know.
Yeah, right.
You are to trust. It's all about trust. It's hard because he does things in mysterious ways.
Sure.
And it's hard because we want to just believe our earthly ways. It's part of you happy. And it's part of you happy. Yes. Part of you.
Go ahead.
Yeah.
That's clear.
And that is the end of the body cam that we were just given today by the Tuscarawas
County. All right, I'm going to pronounce this one right, I promise you. We are still waiting for the trial coverage to start. I like to go to the local channels instead of like Core TV and Law and Crime if I can, because I feel like they have a more vested interest in it. And you could see that reporter actually his compassion as well. So shout out to Tuscarawas County, Ohio, who seem to have very, very well-trained park police or park ranger at Tusk County. I can just call it Tusk. Thanks, Mama Buck. Thank you very much. And so we are waiting for the judge to come into court and to either just render his verdict or to allow the attorneys to do some sort of argument or some sort of a statement before he renders his verdict. This is a bench trial. Approximately 1 week ago, we watched the hearing earlier where the defendant, Ruth Miller, has waived a jury trial. She's opted to go with a bench trial. She has undergone 3 psych evals. One doctor was appointed by the judge. One doctor was chosen by the state, and one doctor was chosen by the defense. And all 3 medical experts have determined that she is indeed, oh, here we go.
State of Ohio, and ask Fred, is there any form
That she is indeed not guilty by reason of insanity. I'm going to have to boost this because the sound is horrific. And so let's see what the judge does. His name is Judge Michael Ernest. Judge Michael Ernest. And this is today's hearing. If anybody pops in, let them know.
of opening statement that the state of Ohio?
Oh, come on,
Judge,
Judge. You better than this.
Time to give an opening statement. I would
Volume is low,
just
right?
like the record to reflect that prior to beginning today, the jury trial waiver, which we discussed last week, there was a written waiver signed by Ms. Miller, and that was filed prior to beginning our proceedings. Thank you.
We do not have any opening statements. We will waive and move forward to the admissibility of our exhibits. Thank you.
With that, Fred, I have in front of me what I believe are the 5, 1, 2, 3. There are the 4 paper exhibits that I have. I don't have in front of me, but they're just simply on my desk. I did not intend to bring out the videos today. But I have a collection of police reports from the Tuscarawas County Sheriff Department, as well as there is one report, I believe, included from the Stinging Watershed Conservancy ranger officer, correct?
Correct. There's also the coroner report.
For those reports, are you asking that all of those reports are admitted?
Yes, it's my understanding with the defense, we're going to jointly move those exhibits in, stipulate to their authenticity and admissibility.
Before I hear from you, Ian, that would be also true then for the report from starting off from forensic diagnosis.
I'm going to switch to this channel and see if it's any better.
2, 3, 4, and 5.
No, I think it's
So
worse.
capture it correctly. We are stipulating as was just described to you.
Maybe they could put some mics in there.
With that then, Fred, is there any further evidence of the state of Ohio?
Is that just as bad or is that any better? What do you say? Hold on, we'll take it back a little tiny bit because it just started.
Also unclassified.
I mean, I think it's worse. Go back here where we just ended. I think that earbuds are going to be your friend today.
Diagnostic Center of District 9, Dr. Ringo. There is also the report from Dr. Friedman from University Hospitals, as well as the report that was provided from the University of Cincinnati, correct?
Correct. So Dr. Hrinko, Dr. Friedman, and Dr. Merritt, all 3 of those reports, I understand we would stipulate the authenticity and admissibility of those, as well as the 2 statements by Ms. Miller. One was an audio statement conducted by Captain Fisher, and the other was a video statement captured on his body.
Ian, I'm here for you on states exhibits 1, 2, 3, 4, and 5.
I think the state captured it correctly. We are stipulating as was just described to you, Your Honor.
Okay, thank you. With that then, Fred, is there any further evidence that the state of Ohio would intend to present.
No, the state would rest based on those exhibits.
Ian, I'll turn back to you for Ms. Miller. Any further evidence that the defense intends to present?
No, Your Honor, we rest upon the evidence which has been submitted thus far.
Okay, thank you. And the court, with those stipulations, will admit exhibits 1, 2, 3, 4, and 5. Keeping in mind, exhibit 1 has multiple parts to it. That would include all of the police reports that were provided. Based upon those stipulations, the court makes the following findings.
Okay, so the judge has reviewed everything, the body cam footage, the police reports, the 3 mental health evaluations, no live testimony. He's had a week to review, and now he's going to decide. He's going to give his verdict.
Findings. The court makes the following findings. I've had the opportunity to review all of them, and I did review all of them before I came out here on the bench today. And I'm making the following findings, including that on or about August the 23rd of 2025 in TUSCARAWAS County, Ohio, that Ruth R. Miller did purposely cause the death of Vincen Miller, who was under the age of 13 years of age at the time of commission of the offense, and born on 10/12/2020, including that on or about August the 23rd of 2025, Ruth R. Miller caused the death of Vincen Miller as a proximate result of the offender committing or attempting to commit the offense of felonious assault in violation of 2903.11A1. I'm concluding that on or about August the 23rd of 2025, that Ruth R. Miller did knowingly cause serious physical harm to Vincen Miller. And concluding that on or about August the 23rd of 2025, that Ruth R. Miller, as a parent or a child under the age of 18 years of age, she created a substantial risk to the health or safety, in this case of Amber Miller, by violating the duty of care, protection, and support. Including that on or about August 23rd, 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Amber Miller and their household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Joel Miller and their household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Jordan Miller and their household member. Now, Ruth, I've also taken into consideration not only the police reports that were provided, but I've read through all of the forensic examinations that were conducted in this case, and there were 3 of them. And I think it might have been said earlier, whether it was out here or in chambers, it truly is unanimous. I ordered that a agency conduct an evaluation, forensic diagnostic 9. Your attorneys retained an individual to conduct an evaluation, and the city, all of us had essentially our own evaluators conduct an evaluation. These are the findings that I have concluded, including that a mental status at the time the offense evaluation was conducted by Dr. Daniel Rinko of Forensic Diagnostic Center of District 9 was identified as a joint exhibit number 2 with generated evidence. In the report by Dr. Rinko, who is a board-certified forensic psychologist practicing with Forensic Diagnostic 9, it sets forth findings the court finds persuasive as to your state of mind at the time of the offense. Dr. Rinko opined that the defendant at the time of the offense charged did have a severe mental disease, but did not have a severe mental defect. His opinion states that as a result of the severe mental disease, the defendant did not know the wrongfulness of the act charged. And that would apply to all of the acts that is charged, not just one of them, but all of them. The next evaluation that I reviewed is the evaluation of Dr. Susan Hatters Friedman of the University Hospital's Cleveland Medical Center, Case Western Reserve University, was identified as Joint Exhibit 3, and he was also entered into evidence. Dr. Hatters Friedman, at the time of the defendant, at the time of the offense charge, also had a severe mental disease and did not have a severe mental defect. In the report by Dr. Hatters Friedman, she sets forth again certain findings which the court finds persuasive as to your state of mind at the time of the offense. Her opinion states that as a result of this severe mental disease, the defendant did not know the wrongfulness of the acts charged, and that would apply to all 7 counts of the indictment. Lastly, I considered the report that was submitted to me by the state of Ohio. The state of Ohio utilized Dr. Christopher Merritt of the University of Cincinnati. Dr. Merritt is a board-certified forensic psychiatrist who set forth certain findings which, again, the court finds persuasive as to the defendant's state of mind at the time of the offense. Dr. Merritt opines that the defendant, at the time of the offense charge, again, has a severe mental disease, but did not have a severe mental defect. His opinion that he states is that as a result of this severe mental disease, the defendant did not know the wrongfulness of her acts as charged. Again, all 7 counts in the indictment. And while, curiously, there was maybe differences of opinion among the doctors as to what the mental disease was in this case, they all concluded that you suffered from some form of mental disease that prevented you from knowing the wrongfulness of your conduct. I would also note, and I'm just going to single out Dr. Merritt. They all have very, very thorough report, but some of these.
Oops. Let me just pause for a moment to tell you what exactly the charges are, because he didn't read the charges. And so here are the charges as I'm going to read to you. She's charged with, there's 7 counts. Grand jury indicted her on 7 counts. 1 count of aggravated murder for her 4-year-old son. 1 count of murder for her 4-year-old son. 1 count of felonious assault for her 4-year-old son. He is the one who is deceased. 1 count of child endangering for her 15-year-old daughter. And 3 counts of domestic violence for the 15-year-old daughter and the twin 18-year-old sons. And the reason that there's only 1 count of child endangering or endangerment, it says endangering in the thing I'm reading, is because the twin sons were 18 years old and so considered adults. And so all 3 experts, the one chosen by the judge, the one chosen by the state, and the one chosen by the defense, all agreed that Ruth Miller, 40 years old at the time of these offenses, did not know the wrongfulness of the acts with which she is charged. So we will see what happens next. This is Judge Michael Ernest, and this is Tusk County. I was told I can call it that, Ohio.
Findings are worth noting as well, and that is, it's not just the 3 doctors who came to this conclusion that you did not recognize the wrongfulness of your acts. There are numerous witnesses who have contact with you on the days leading up to this event, that have contact with you on the day of the event, and also shortly thereafter. And to some extent, their observations and opinions here, I think, are relevant as well. Specifically singling out, though, some of the summary that was noted by Dr. Merritt. He says Ms. Miller described in the weeks leading up to the alleged offense having shortened and erratic sleep. She described having a euphoric mood at times, which felt like she was getting married all over again. Grandiose, distractible, and at times had racing thoughts. Ms. Miller described descriptions of her belief, particularly those about tests and her expected ability to reflect a grandiose and delusional thinking. She ordinarily did not believe she would or had ever had the ability to walk on water, but she also believed that God had asked her to be swallowed by a fish, and she asked that her husband at one point in time to suffocate her. These reflect delusional and distorted thinking, which she did not otherwise have outside of mental health episodes. Talks about medical records supporting these same observations that you had made. He talks about eyewitnesses, law enforcement officers offering their observations that Ms. Miller's behavior was suggestive of a person experiencing an acute mental health crisis. For example, he says, Officer Hayden Edwards wrote in his initial report, while speaking with Ruth, it appeared that she was not in a correct mental state. Due to this, the Rangers and I determined that Ruth needed mental health evaluation. That same type of conduct, I think, is reflected by numerous witnesses in the police reports, both leading up to the events at issue and shortly thereafter until you receive proper care. Based upon these findings that I have made in this case, I am concluding that pursuant to Ohio Revised Code Section 2945-37, that the defendant, Ruth R. Miller, is not guilty by reason of insanity. I think that's the only conclusion that can be reached in this case based upon the evidence that's been presented to me.
Judge's verdict is that she is indeed not guilty by reason of insanity, that it is proven beyond a reasonable doubt.
Ruth, after and concluding that you are not guilty by reason of insanity on all 7 counts, aggravated murder under 2903.01C, murder under 2903.02D, and youth felonious assault under 2903.11A1, endangering children, count 4 under 2919.22A and E, domestic violence, counts 5, 6, and 7, all misdemeanors of the first degree under 2919.25A will have the conclusion that the evidence supports in this case, and that is not guilty by reason of insanity. Now that a determination has been made that you are not guilty by reason of insanity, the next step will be determining the final disposition regarding the least restrictive conditions that can be placed upon. Before I go into that, though, is there any further to state on the
Not from the state.
Nothing further. Thank you, Ron.
Okay. And just confirm March 13th. That's what we agree on.
Yes, Your Honor, just briefly though, for the court's consideration as well, we will submit today 2 additional reports for the court's review prior to the March 13th date that have already been provided to the state of Ohio, and we'll separately provide to the court via email the curriculum details for both experts as they were significantly long. That'll be for Dr. Hatteras Freeman and Dr. Daniel Buffington. Thank you.
One thing I don't have on that is the time.
At 10 a.m.
It's at 10 a.m. All right, so what will happen, Miller, is we'll go back here on March 13th at 10. Each side will have the opportunity to present to me as to what their respective positions are regarding essentially your placement going forward. And I heard that I know that you will be submitting that. I have read that you said that the state has its doctor, and I am going to reach out to District 9. I want to have their input as well as far as a recommendation. Don't be surprised, I'm guessing that they will be reaching out to you. I could be wrong on that, but I'm guessing they will have some contact with you. But I am going to Dr. Ringo to get an opinion as well. We're going to have you remanded back to the Tuscarawas County Jail. The law allows in Ohio to you to be confined during those 10 days leading up to that hearing. Is there anything further from the state?
No, no.
No, Your Honor. Thank you.
Double check my notes here. Is there anything else we need? Ordering assessment to be completed. Talked about the hearing. And the last thing is this, the findings that I made here in open court, will be reduced to a judgment entry. It's a paper document reflecting what had taken place here at this bench trial today. It'll be sent to your attorneys. They can provide it to you as well as to the state of Ohio. We will reconvene in this matter otherwise on the 13th. Nothing further? Nothing further.
Thank you, Your Honor.
I wonder if her older children are in the courtroom. Shuffles off. That was interesting too, because she wasn't even held by any of the sheriff's deputies or any of the court officers as she walked out. There's a lot. We have a lot of opinions in the chat. We're going to talk about them in a sec. But there's a lot of people who are conflicted by this whole thing. Watch how she's just permitted to walk out, and I guess she's in some kind of shackles by herself. She's not escorted. Nobody's touching her. Watch. This is Tuscarawas County. Tuscarawas. You guys thought I said it right. Tuscarawas.
Yeah.
Me too.
Somebody just said, I'm dehydrated. And the other person said, me too. All right. Lots to talk about here. Lots to talk about. First time, I think, ever in a very long time. I can't even remember a case where the state and the defense both agreed that the client was, in fact, not guilty by reason of insanity. And the state, showing some grace, didn't push a trial, didn't push a verdict, didn't fight. 3 mental health experts deemed that she did not know wrong from right at the time of her crimes. And she asked for a bench trial. The judge allowed it. He's had a week to review all the evidence, and he just agreed. He just gave his verdict. She is not guilty by reason of insanity. Now, that does not mean that she's going to be let out on the streets. That is not what that means at all. Not what it means at all. Likely, she will spend more time in a mental institution than she would in prison. So that's not what that means. Let's take a look. And then, if you like, I will find the LINDSAY CLANCY hearing from yesterday in Massachusetts. And we can take a look at that as well and see what the difference is between Ohio and Massachusetts, where they are fighting every step of the way to incarcerate LINDSAY CLANCY for the rest of her life. Some of you seem to have some grace for mental illness, and many of you are very angry about what just happened. And so I find it interesting in a lot of ways, says Sadie. And Emily C says, the world for once in perfect harmony. There will be a sentencing on March 13th, which is basically, as the judge said, just for placement. And so that is what's going on here. Let me go to the chat for a moment. Thank you, Karen DePasquale, for gifting 5 memberships, and Tina's Window for your super sticker. Nate Taylor, thank you for your 20. She says in Rhode Island, Brown Health has social workers that work directly with our police. They go on all calls that need mental health support. This aids to avoid arrests and put people with programs that they need. All states should have this. Yes, all states should have that. I agree. Thank you for your 20s. Thank you for your 20. Charlie says, and the elders who asked the family to walk on water to test their faith. Yeah, they're not being charged with anything. Is that what you're asking? Thanks, Charlie, from Down Under for your super chat. And Frisvold said, did they ever figure out what happened to the father? The father thought he could walk on water, drowned himself. They found his clothes. And then when the divers went to search for the body of the 4-year-old, they found his body as well. But I believe the father and the mother went down there first to the lake. She went back to get the 4-year-old. The father never returned. But his body was found the same day as the little boys, and that's horrific. Kellen said, this is the town I grew up in. It is so sad. It is so sad. Connie Lewis says, sorry, I live in Ohio. This was devastating. As a mother who has lost a child, I refuse to have any sympathy for this woman, no matter if she has mental issues. Thank you, Connie, for your thoughts. Many people feel the same way. D Lawyer Life came back to tell me that she's not race baiting me, but she's asking a genuine question. As a criminal defense attorney in Massachusetts, oh, you practice in Massachusetts. That explains it. I see the difference every day. The benefit of the doubt is given to some and not to others. Well, yeah, I'd like to know your thoughts on, as a criminal defense attorney, your thoughts on what is going on with Kelsey Fitzsimmons, and your thoughts on what is going on with LINDSAY CLANCY, and your thoughts on what happened with Joshua Hubert. Did you file that case? That's a black man who was convicted of throwing a young girl off a bridge, but there was some evidence that he wasn't even in the area at the time. He was recently convicted. Hold, please. Jenna wants to know if LINDSAY was brought to court or zoomed in. She zoomed in. We're going to look at that in a moment. New Hampshire woman also does not seem to think that mental health should be allowed as an affirmative defense because it makes her so angry. And I saw a couple of other comments of yours, New Hampshire woman, in the chat saying the same sort of thing. Eve says that this is sending a message that Amish children deserve no protection under the law. You guys in the chat can let me know how you feel about that. And Joanne says, where's the line between religious fanaticism and mental illness? The test in Ohio is, did the defendant appreciate the difference between wrong and right at the time that they committed their crime? And 3 medical experts determined that she did not. And that is what the judge based his verdict on. Thank you for your super chat. So in Ohio, when there is a verdict of not guilty by reason of insanity, and I misstated the burden before, the burden is by a preponderance of the evidence. So it's really just a little more than 50%. It's not beyond a reasonable doubt in Ohio. Hold, please. Sometimes you got to put the family group chat on mute, or it will continue to keep interrupting you. Even though my kids always check to see whether I'm on the air before they start texting me. When the group chat is, the group chat is the group chat. The defendant has to prove for a not guilty by reason of insanity affirmative defense by a preponderance of the evidence that a severe mental disease or defect made them unable to know the wrongfulness of their act. If successful, they are not criminally punished, but are involuntarily committed to a psychiatric facility, potentially for a duration similar to or exceeding a prison sentence. And they follow the Monotone rule, which is the inability to understand the wrongfulness of actions due to severe mental illness. And if you're just tuning in, then you didn't see the body cam footage from the park rangers who responded to the scene initially. You can rewind a little bit to see it and let me know what you think. And she did undergo 3 separate psych evaluations, including mental testing, and if found not guilty by reason of insanity, which is this judge just decided was his verdict in this case, she opted for a bench trial 1 week ago. He took a week to review all the documents, police reports, body cam footage, and all mental health evaluations, and did find her not guilty by reason of insanity. But on March 13th, there will be another hearing to determine her placement. If found not guilty by reason of insanity, the court commits the person to a mental health facility if they are found to have a current mental illness or intellectual disability pursuant to the Ohio Revised Code Section 294540. With regard to their release, the court retains jurisdiction to manage the defendant's treatment, including decisions on transfer, trial visits, conditional release, or final discharge. Apparently the duration of the involuntary confinement to the mental health facility are often comparable to what they would have served in prison, and sometimes longer. Let us now go to the Ohio rule, in which what happens next is set forth. And this is Ohio Law and Administrative Rules, Section 2945.40. And this is the acquittal by reason of insanity statute under criminal law. If a person is found not guilty by reason of insanity, the verdict shall state that finding, and the trial court shall conduct a full hearing to determine whether the person is a person with a mental illness subject to court order or a person with an intellectual disability subject to institutionalization by court order. Oops, what just happened? Well, I think that's better anyway, is it? Prior to the hearing, if the trial judge believes that there is probable cause that the person found not guilty by reason of insanity is a person with a mental illness subject to court order, or a person with an intellectual disability subject to institutionalization by court order, the trial judge may issue a temporary order of detention for that person to remain in effect for 10 court days or until the hearing, whichever occurs first. Any person detained pursuant to a temporary order of detention issued under this division shall be held in a suitable facility, taking into consideration the place and type of confinement prior to and during trial. B, the court shall hold the hearing under Division A of this section to determine whether the person found not guilty by reason of insanity is a person with a mental illness subject to court order or a person with an intellectual disability subject to institutionalization by a court order within 10 court days after the finding of not guilty by reason of insanity. And so that is the hearing that is going to happen on March 13th. Failure to conduct the hearing within the 10-day period shall cause the immediate discharge of the respondent. Oh, wow. So if they don't hold this hearing within 10 days, today's the 3rd, they have to hold it by the 13th, then the defendant will be discharged immediately, unless the judge grants a continuance for not longer than 10 days for good cause shown or for any period of time upon motion of the respondent. That's why it is so important to hold that hearing within 10 days. The defendant has the right to attend all hearings, the right to be represented by counsel, the right to have an expert evaluation, the right to subpoena witnesses, to present evidence. I don't know if they're going to do this because this was a bench trial. The right to testify. Section F says if the court finds by clear and convincing evidence that the person is a person with a mental illness subject to court order, and I believe he's already decided that, the court shall commit the person either to the Department of Mental Health and Addiction Services for treatment in a hospital, facility, or agency as determined clinically appropriate by the Department of Mental Health and Addiction Services, or to another medical or psychiatric facility as appropriate. Prior to placing the defendant, the Department of Mental Health and Addiction Services shall obtain court approval for that placement. That's what the 13th is going to be, a placement hearing. So we will see what he does, but it seems to me that she may wind up spending more time in a mental institution. Well, I guess the penalty under the murder that she was charged with is probably life. They do have the death penalty in Ohio still, right? But it seems like that was not on the table for her. Hold, please. And so, if you would like to continue covering this case, we will go and we will cover the hearing again. The next hearing, I should say, on the 13th of March. Jan Mike says this topic is a real moral dilemma, so difficult to be correct in decision making. I mean, it's so rare. It's so rare for the state to just agree and show grace and not fight it. I don't remember the last time I've seen that happen. We watch the Commonwealth of Massachusetts fight everything at every turn. Everything. We've seen the courts in Massachusetts take a woman's breastfeeding infant away based on the ex parte application of her ex-fiance who may have been jilted. Kelsey Fitzsimmons. You guys want to keep covering? Okay, we're going to keep covering because it's so interesting to me how different things can be when you just cover proceedings in other states and how some states are seemingly more sympathetic to the mentally ill than they are in others. Kelly says, not guilty by reason of insanity is therefore a reason, and anyone, including those in here against it, would expect it for their relative. 3 professionals agreed for once. It never happens. I mean, it never happens. I don't see her ever being let out either. I don't see it. Full of questions, Barbara says, I don't see her being let out. The only difference is a hospital over a prison. Oh, thanks, Margie, for reading the show notes. A lot of people don't know that they're there. And so when you know nothing about the case, you can go right down there and check it out. Yes, Mo. Respect for taxpayers' money. Say it ain't so. Right. Trials are expensive. Most of the prosecutors that we've seen, many of them are very, very good. Many of them are just out for the conviction. They're just out for the conviction. They don't want the truth. They just want the conviction. Let me introduce you to the case of the state of Georgia versus Edric Faust. That's a trial that we just covered in Athens, Clark County, Georgia, in which a black man was convicted for the 25-year-old cold case murder of a girl named Tara Baker. There had been many suspects in the last 25 years because the forensic evidence showed only Caucasian hairs and Caucasian DNA, or not DNA, but Caucasian hairs and Caucasian. There was never a black suspect in the entire case until 25 years later, when all of a sudden they needed to pin it on somebody because the Coleman-Baker Act was enacted, and that allocated $5 million to cold cases. And very sadly and tragically, Tara Baker was a law student back in 2001. The act was named for her, and in my opinion, they needed to close that case to prove that it was worth their $5 million. So they had to find somebody to pin it on. in my opinion. And they found a patsy by the name of Edric Foss, and that should frighten you. Thank you, Jomar. Ms. Holmes says, what Amish religious doctrine is or was she abiding by? Amish people in Ohio have lived only miles away, and I don't recall something like this according to Amish beliefs. I am not an expert on Amish beliefs, and so I cannot answer that question for you. There may be some people in the chat who are, and if you are, and you have an answer from Ms. Holmes, if any, Amish religious doctrine or belief, please tag Ms. Holmes. Maximum Bacon says, I mean, with 3 assessments all in agreement, including the state, this was the only way this could go, right? Legally, that is. Well, she could have had a jury trial and risked it and left her fate into the hands of 12 strangers that may not understand the legal nuance that many of you do understand and could still have found her guilty, but not including the insanity defense at all, because there's a lot of feelings in the chat that she should go to prison and not a mental hospital. And it seemed like she was having mental breaks. That's why it's so important to, like, I don't know, if you see something, say something. If you think a person needs help, maybe do something about it. I mean, how many people ignored this woman's delusions? Delusions of grandeur. Clearly, maybe she was having hallucinations. Obviously, her medical evaluations are not public, and nor should they be. Full of questions. Barbara said it wasn't Amish-based belief. She had a mental break as a religious person. Law and Disorder said the issue here is not religious choice or lifestyle. It's about mental health. Law Junkie says Amish do not believe in mental health treatment. That I did not know. So how will they rehabilitate her? That's a great question. No, the father went into the water before she brought the son to the water. So the father did not go in to save his child. The father and the mother both were trying to prove their faith and thought they could walk on water. And I think that the husband just never came back. And it was after that that she brought the 4-year-old down to the water. So I don't think the father was trying to save the child. J.R. Walker wants to know, was religion even brought in by the court or anyone other than the press? No, I don't believe so. I am Ted Sco says her Amish beliefs don't play a part of the state ruling. She will be treated the same as any other mental illness defendant. Everyone, please remember to hit the like button. Let's do this while we're thinking of it. It helps the video, as does commenting on the video after we're done live. Did she say why she did this to her child? Yes, she said she was giving her child to God. That is what she said. We watched the body cam footage before, so rewind and you'll see it again. Scott McGinnis says exactly. The DA gets no political points for another conviction, no victory lap presser outside of court. And those of you from the area, let me know if this is the way it goes. If this is the way it goes in Ohio, if your prosecutors have a lot more, I don't know, common sense and grace and maybe don't care so much as a conviction as justice. Let me see if I can find a feed of the LINDSAY CLANCY hearing from yesterday. Well, Court TV has the Zoom feed, but I watched it live. What channel did I watch it on yesterday? I think it was Boston 25. Hold, please. They had a real camera in there. And let's see what happened yesterday with Kevin Reddington and his arguments in court for LINDSAY CLANCY, who is also accused of, or likely did, take the lives of her 3 small children with exercise bands and then went up to her second floor in her Duxbury home, Massachusetts, and jumped out the second floor window trying to take her own life, but survived and is now paraplegic. Her trial's coming up, and it's been more than 3 years in the making. Well, Embassy Boston had to take it down after the live stream. Let me see if they put it back up. She was brought in person, yeah, 2 weeks ago or whenever that last hearing was, but it looks like Court TV only has, I don't know why Boston 25 would take down their live stream. I guess they were required to right after. So it looks like we're going to have to watch the Zoom feed, but we get what we get. Please. Oh, please. Oh, you know, we forgot to do, we got to read our motivational quote of the day. Our motivational quote of the day. Today is Monday, March 3rd. And this is a little bit prophetic considering what we just are covering today. This is a quote by Marcus Aurelius. It is not death that man should fear, but he should fear never beginning to live. It is not death that man should fear, but he should fear never beginning to live. And that is a Marcus Aurelius quote. It's your motivational quote of the day. Huh. It's Tuesday. What did I say? What did I say it was? Tuesday, March 3rd. Did I say it was Monday? Did I say it was Wednesday? I don't know what day it is ever. I don't know what day it is ever. All right. Well, we pivot to the Lindsay Clancy hearing from yesterday. Oh, please. Just to catch you up, Lindsay Clancy's attorney, Kevin Reddington, who is one of the best defense attorneys in Massachusetts, has asked the court to bifurcate her trial. He wants her trial to be 2 separate phases. He wants the first phase to be the jury determines whether or not she did, in fact, take the lives of her children. And he wants the second trial to be whether or not she knew right from wrong at the time she's committed the acts. And I think it's a good argument. We'll see what, if anything, the judge in Plymouth County Superior Court, Massachusetts, does about it. There we go. What day did I say it was?
Session, you may be seated. Good afternoon, Your Honor. Good afternoon, all. This is 2383 CR 198, the case of Commonwealth versus Lindsay Marie Clancy. This case is called for motion hearing. Counsel for the record, begin with the Commonwealth.
Good afternoon, Your Honor. Jennifer Sprague for the Commonwealth.
Tree Spring, good afternoon.
And Shannon Buckley here, also for the Commonwealth.
Buckingham, good afternoon.
Good afternoon, Kevin Reddington on behalf of Lindsay Clancy, who I believe is with us on Zoom.
Tree Reddington.
All right,
good afternoon.
Good afternoon.
All right, so.
Okay, this is not boosted. Can you hear it okay? Not boosted? Or does he need to be boosted and distorted?
This was put over today in regards to a couple of motions that had been filed by the defendant. Commonwealth filed their opposition, which I had an opportunity to go over. So why don't we deal with, there was a motion regarding juror information. My thought on that was to maybe defer on that, only because we're going to have to figure out, so early in the situation now, we're going to have to find out how many jurors are coming in, who's coming in. I have no problems allowing that motion, but just to have a better idea of the specifics. That was kind of just my thought, but well, I guess Mr. Reddington, your motion, I don't know what your thoughts are in regards to that.
I know when to defer, and I'll defer to you in your judgment in that regard, because obviously you're not opposed to our getting access to the jury information well in advance of trial for us to do our investigation. So that's fine.
All right, Como?
I have no objection to deferring either. I just would point out that the Commonwealth filed its own motion because we're looking for slightly different information and we're objecting to a portion of the information defense is requesting. So I do think at some point we just need to hash that out.
All right, we can do that right now.
Okay. The only thing we're objecting to is the contact information of the jurors. I don't think we're entitled to that, and I don't think we should have that prior to trial. And that, I believe that was in defense counsel's motion. In our motion, we're just looking for the dates of birth, the addresses, and the names.
All right, Mr. Reddington?
I agree, Your Honor, that my understanding of the status of the law as it relates to contact with jurors is that once we actually start a trial, we're not supposed to, for obvious reasons, which is fine. And then you have the Fiddler case, talks about post-verdict. I tend to agree as far as the request for contact info. I would not be thinking in any fashion of having a private investigator go out and talk to potential jurors or anything. I just need to know who they are and their addresses. That's all.
All right, so my inclination would be not to allow the contact information, but the rest of the information. So my thought would be to put this off till a little bit farther down the road so we know kind of when we can get that information, and then I can kind of tailor the order along with that after we talk to the jury commissioner and figure out the jurors that are coming in. But like I said, I'm inclined to give that other information to both parties in advance of the trial impanelment. So, all right. The other motion that we had was regarding the bifurcated trial. So why don't, Mr. Reddington, I'll hear you on that, and then I'll hear from the Commonwealth.
Thank you. Your Honor, first of all, as you know from looking at my motion and the memoranda, and also from looking at the government's opposition, there is a bit of a dearth of law on this issue, quite frankly. I think that's not just statewide, it's pretty much nationwide. But one of the...
Court TV needs to learn how to pin the speaker if they're going to record this and put it up on their website so that we can actually see Kevin Reddington. Ridiculous. I don't know if I can zoom in on him. Let's see. I'll do my best. Here's LINDSAY CLANCY appearing by Zoom from
the things that's
Tewksbury Hospital, as big as it can be. And then Kevin Reddington is on the left of your screen. He is in court arguing in front of the judge in Plymouth Superior. I think this is Judge Sullivan. You can correct me if I'm wrong. Okay, here we go.
Really compelling to me in reviewing the language from the various opinions is that there's no doubt that this is commended to the sound exercise of discretion by the trial judge. So you've got two issues in play here. Number one, do you, as the trial judge, feel that, in fact, it's a legitimate concern that we've raised and it's a legitimate procedural proposition that we present to the court as far as the logistical considerations involved in trying the case in a bifurcated sense, and then also the constitutional implications, if any there are? And I suggest to the court that, first of all, the government has quoted the many times quoted Siegfried case, 88 case, dealing with a guy that burnt down a dwelling house, and they're talking about basically the introduction of the evidence of prior testimony of a witness in a probable cause hearing, and the witness was then unavailable. But in dicta, they do talk about the fact that it does not appear as though there is a constitutional, let's say, obligation, if you will, on the part of the court to provide a defendant with the bifurcated trial. But they don't really get into a consideration of that, and they don't really get into a discussion of it. They talk about cases that had been cited in the past, Commonwealth versus Bumpus, MacArthur versus California, and these go back, they go way back. Cromwell versus Stewart at 359 Mass is one that where the court notes that the one issue that's of a concern is that you have the issue of criminal conduct is their language, the way they use it, criminal conduct and criminal responsibility. So we have two separate concepts that would have to be presented during the course of the trial to a jury. One, whether or not the defendant is in fact determined by a fact finder to be guilty of the offense as indicted or any lesser degree thereof, and whether or not that person has the mental, and again using the SJC language, mental responsibility. Now I think that the cases are fairly old, that's 78, thereabouts. So that's why they're using language such as mental responsibility. As we all know now, we're talking in terms of the defendant having the ability to know, and the government's burden of proof. The government's burden of proof, beyond a reasonable doubt, not only as to whether the person has committed the offense, but whether or not the defendant at the time of the commission of the offense was suffering from, or was not, I should say, on the government's obligation to prove to a jury, defendant was not suffering from a mental disease or defect, such as preventing the defendant from either, it's in the disjunctive, either understanding or appreciating the criminality of his or her conduct, or to be able to comply and conform to the requirements of the law. That's black letter law definition of the lack of criminal responsibility, which is a separate issue and has been recognized as such by the SJC, as I say, in Cromwell versus Stewart. I believe in some other cases in dicta, they recognize the fact, which we all, I think, recognize, that there are two issues: defendant's mental state and whether or not the defendant committed the offense. Now, this is where it gets into what I think is very interesting.
Okay, before he talks about why he wants this trial to be bifurcated, which means split into two parts, you just heard him tell you, as we discussed earlier, the difference between a not guilty by reason of insanity plea in Massachusetts and in Ohio. In Massachusetts, if a defendant pleads not guilty by reason of insanity, the burden shifts to the prosecution to prove that she was not legally insane at the time of the murders. And they have to prove that beyond a reasonable doubt. I mean, that's crazy burden shifting, right? In Ohio, the defense has to prove that the defendant was not guilty by reason of that the defendant was insane, legally insane at the time of the crime, but the burden is much less. It's only a preponderance of the evidence, not beyond a reasonable doubt. Will the Commonwealth be able to prove in this case that LINDSAY CLANCY was not legally insane at the time she murdered her 3 children? Because I don't think that's in dispute here. Everyone knows that she did it. It's just, was she legally insane? And will the Commonwealth be able to prove that beyond a reasonable doubt to a jury? I mean, I'm kind of thinking that LINDSAY CLANCY might want to opt for a bench trial in this case. I like Judge Sullivan. It's Judge Sullivan, right, Scott? And I don't think a jury in Massachusetts is going to be able to understand the nuance here. I just don't think they will. They're going to go with their feelings. Many people think she murdered 3 children. She should get no grace at all. My thoughts are, how could anybody who is legally sane and kill their 3 children? She's got time to decide, but I don't know. Do you leave this in the hands of a judge? Because the Commonwealth is going to have to get an expert to prove beyond a reasonable doubt that she was not insane when she did this legally. And a jury, in my opinion, a jury's going to be like, done, guilty. She killed 3 kids. She deserves no grace. She's a rich woman from Duxbury. She had everything. What the hell's wrong with her? We don't believe in postpartum depression. We don't believe that's a real thing. Postpartum psychosis. Kevin Reddington has openly told this judge, my client is suicidal, judge. And I don't want it on my head. And I'm sure you don't want it on your head. that if she cannot be accommodated to come to her trial every single day safely, that if she tries to do something like take her own life during the trial in this courthouse, I'm sure you don't want that on your head either. Juries are scary. I don't know. Risking it all on a jury is not something in a case like this that I think that I would necessarily do. All right. Yeah. How many mind altering medications was she on? I have a very long, I don't know how long it is actually, a playlist on LINDSAY CLANCY, and we went over her recent medical malpractice lawsuit that she filed against her providers. She was on a ton of medications that should not be taken together that may have caused her to lose it. All right, let's listen to why Kevin Reddington is arguing the case should be split into fault and then insanity, legal insanity.
Interesting. Now, mental state and whether or not the defendant committed the offense. Now, this is where it gets into what I think is very interesting as it relates to the Massachusetts Constitution as opposed to the federal Constitution. Now, the Massachusetts Constitution, as your Honor is well aware, predates the United States Constitution. And in fact, the framers of the United States Constitution drew upon language, for example, on the issue of the Fifth Amendment. They drew upon language that our framers of the state constitution said that no person shall be compelled to give evidence against themselves. U.S. Constitution talks about no person shall be compelled to give testimony against themselves. So there's a difference there, as your Honor is well aware. Excuse me. So when you consider the Massachusetts Constitution and the fact that that has traditionally provided greater protection to a citizen than the United States Constitution, I'm suggesting that under the Massachusetts Constitution, coupled with the dichotomy between defendant's mental state and the commission of the crime, coupled with the government's obligation to prove beyond a reasonable doubt, and then coupled again with the defendant's constitutional right not to make any effort to present any evidence against himself or herself, that in fact, the court should be able, in the sound exercise of discretion, to determine that if you have a trial and the defendant is compelled to go to trial not only on the obligations that the government has as to proving guilt of the offense, whether it's a bank robbery, whether or not it's an alleged rape, whether or not it's a homicide, the government has to prove that the offense occurred. However, you've also got that next layer, which would be whether or not the defendant has, as the SJC says, mental responsibility. So if you consider it in that fashion, we do not have to present and should not have to present evidence in the, let's say, guilt phase of the case. So if you have the guilt phase of the case, and then you have the criminal responsibility phase of the case, if Your Honor denies this motion, we tried the case the way they're all tried. Government presents their case, presents their evidence, determining whether or not jury's going to find this defendant guilty, then I have an obligation to present evidence that would be consistent with the lack of criminal responsibility, and evidence of that lack of criminal responsibility will obviously implicate criminal liability.
Okay, does Court TV have nobody manning this live Zoom feed? First of all, there's an option where you can hide non-video participants. Okay, and then there's an option where the speaker at the Zoom hearing is the speaker of the Zoom hearing is in fact highlighted. Okay, so do I need to go run their Zoom for them over at Court TV? I feel like I shouldn't have to. But this is what we have here, okay? Don't call that phone number. But Angelina is here. We can tell that. Angelina was there yesterday. Mastad, if you're still here, where's my criminal defense attorney from Massachusetts. Are your trials in not guilty by reason of insanity cases typically not bifurcated? Because it would seem to me that they should be.
So that's the problem that we have in this type of structure that we deal with. And that's why I think that it's very, very appropriate to have the bifurcated trial as requested in the motion. So looking at the other cases that I've looked at, I think clearly where you have the U.S. Constitution, they have the, let's say, the minimal protection. The Massachusetts Constitution provides a greater protection. And a defendant should not be placed in a position of presenting evidence in the course of a trial because, for example, in the grand jury, you have wonderful first responders. And what these people went through is just horrific.
Right.
But they had one witness after another, after another, after another, after another, firefighter, EMT, police, all describing the same thing that they saw when they went into that house. And that's going to be a replay on the trial itself. So the government should be in a position of presenting their evidence on criminal activity without trampling on the defendant's right not to be presenting evidence, quote unquote, against herself in that phase of the trial. And if we were to have the bifurcation, that would solve that problem.
Let me ask you, because
Tell me what you think about this. Emily C. says, I know this doesn't need to be a factor in their decision about choosing a bench trial, but a bench trial spares 12 plus alternate people on the jury from the trauma of having to see the crime scene pictures. I could not stomach that. No way. Kevin Reddington is a very smart man. He's a savvy attorney. And he's also very gregarious and friendly from what I've heard. He said nice things about me in open court. So I'm happy about that. But he gets it. And you can see when he talks about Lindsay, that one hearing that we watched about the logistics of getting her to come into court every day and how difficult that was going to be because of her paraplegia and the needs that she was going to have in court and being able to go to the bathroom and things like that. He really cares about her. He has a lot of empathy for her. So traumatic. Yes, Letteros by Bettero. Hello. She says they have a text message. They claim Lindsay planned this because she sent her husband to get takeout food. She knew how long it would take and seized her opportunity to commit the crime. Really? We also learned from her lawsuit that she filed that she was hearing, she had auditory hallucinations. She was hearing voices, and she had told medical providers that before all of this happened. This could have been prevented, in my opinion, too. That's a matter for a civil case. But yes, you are correct. Karen from Kentucky says, after working 22 years as a CO, God bless you, I saw quite a few inmates who were mentally ill, and you just knew they didn't belong in prison. Prisons are not set up to manage people who are out of touch with reality. Compare this case also, the Ruth Miller case, with the case of Carly Gregg that we watched in Mississippi. A 14-year-old girl tried as an adult for taking the life of her mother. We saw part of it on video. Remember the surveillance cameras in the kitchen? We saw her get the gun, go into the mom's bedroom, shoot the mom. We heard the gunshots, and then we saw Carly come back out and hide the gun and run away. And 14 years old, tried as an adult in a Mississippi courtroom. She will never, ever, ever see the light of day again, because she was sentenced by the judge to life in prison with ever the possibility of parole. And in my opinion, she was suffering a severe mental break at the time because her family, her stepfather and grandparents and everyone stood behind her and said, this is not who Carly Gregg is. This is not, something happened. And she was also had been prescribed medication. So we're seeing such a difference in the way the states are handling this. I find that really interesting. Let's hear what else Kevin Reddington has to say, or let's hear what we're up to, what the judge has to say about this.
I did have an opportunity. I read through kind of the same cases everybody's read through, you know, Siegfried, Blanchett, all these other cases.
Right.
And I would agree, phrase dearth of law does seem to apply. How would you suggest procedurally doing this?
That they proceed with their evidence as it relates to the circumstances involving the death of the victims in this case, and the circumstances surrounding what the police observed, circumstances surrounding any, as the government argues on murder cases, whether or not a person had knowledge, whether or not a person took pleasure in, for example, the suffering of the victim is one of the Hunter and Cuneen factors that we've talked about over the years with first-degree murders. That all goes on the issue of criminal liability. Doesn't really touch upon criminal responsibility. So in the event that in the first phase of the trial on the responsibility coming after, I suggest to the court a jury could return a verdict. They could say, okay, we've determined that the government has sustained its burden of proof beyond a reasonable doubt. We find the defendant guilty based on the facts that have been presented, and then it moves into the issue, which really is the main issue in this case, of lack of criminal responsibility.
So I guess what I'm struggling with is the jury would come back with a verdict
based on the facts.
Based on the fact, guilty or not guilty. We'll assume it's guilty.
Correct.
And then will you ask them to undo that?
No. Then you get into the second phase of the case, which deals with criminal responsibility, which has got to be a major consideration. And it should be a major consideration, which it would be if it's bifurcated. And if you have the initial phase is resolved by way of the factual evidence that the government has, telephone call made, 911 call made, witnesses appear, witnesses observe, witnesses saw, pathologist, results of the pathology examination, all of that goes in the first phase of the case. Then after that is resolved, we get into the issue of lack or presence of criminal responsibility. And then we get into the issue of whether or not defendant was suffering from a disease or a defect, as a result of which she was unable to appreciate or conform.
I mean, it seems very logical to me. Maybe you can use a jury on the first part of that case where the jury determines whether or not she did it, and then take a bench trial on the second phase of the case where the judge determines whether or not she was legally insane at the time of the murders. I don't know why the judge is having a hard time understanding it, unless this is something that's never done in Massachusetts, unless this is a novel idea on the part of Kevin Reddington. I will say also, having practiced my entire career, more than 30 years in New York, state and federal courts, civil litigation, injury cases are bifurcated in New York, which means there's one trial, or the first phase of the trial is on fault. Whose fault is it that the plaintiff was injured? And then after fault is determined, and in New York, we use comparative negligence, so a jury can decide 50%. The plaintiff was 50% at fault and the defendant was 50% at fault. Then the jury comes back and decides on damages. Then they talk about the injuries and how much the injuries are worth. And then the jury gets to decide or award a monetary verdict at the end of the case. And it makes a lot of sense, because if the jury hears during the liability phase, let's say it's an intersection accident, for lack of a better example, and both parties had a stop sign, and then they both stopped and then they both collided, right? Which is kind of hard to determine liability sometimes, depending on the points of impacts of the cars, etc. But if the jury hears during that part of the case when they're deciding liability that one of the parties was killed in the accident and the other one walked away with scratches, they might just want to find liability on behalf of the person who didn't die for justice. Do you see what I'm saying? And so it makes more sense for them not to hear about any injuries in the first part and just decide liability and then move on to the damages phase. So it's something that we do hear all the time. It's the way all injury cases are handled in New York. I'm not sure about criminal cases because I'm not a criminal attorney, never have been, never claimed to be. But it seems to me like this would make a lot more sense. And I guess it's just not typically done in Massachusetts.
So, all right, Commonwealth.
Thank you, Your Honor. The Commonwealth presented 3 basic reasons why we're opposed to this motion.
And here's the thing about Massachusetts that I've learned way too much about the Massachusetts court system since I started my YouTube channel 2.5 years ago, I think, is that the Commonwealth, the prosecutors in the Commonwealth fight everything. They give nothing. They fight everything. If you can remember the last time the Commonwealth actually agreed with the defense on anything, let me know. Because it doesn't happen. Remember the Penny McGee case? Penny McGee was a woman, a former socialite who was on trial in Norfolk County, Massachusetts. She chose a bench trial very wisely. She had a verbal argument with her husband or estranged husband, and he dropped dead of a heart attack in the foyer. Okay. And they prosecuted her for manslaughter, Penny McGee. And even though the ridiculous medical examiner said, well, I can call this a homicide because there was 2 people in the room when he dropped dead of a heart attack. The Penny McGee trial was awesome. And so go back and watch it. It's very short because we could hardly get any coverage on it. Judge Cannoni, who was on the bench, quickly acquitted her without even taking a little break. But the Commonwealth gives nothing ever, I feel like. And so, of course, they're opposed to this motion. That's what MassDad thinks they're going to say. Let's listen. Here's why the Commonwealth is opposed to the motion.
Thank you, Your Honor. The Commonwealth presented 3 basic reasons why we're opposed to this motion. The first, obviously, is that the defendant does not have a constitutional right to a bifurcated trial. And that's not just from the Siegfried case in 1988. It was citing Bumpus from 1972, but it was also upheld in cases in the 80s as well as the 90s, as most recently in a case I found in 1996. So this is something that's been law in Massachusetts, that you're not you're not entitled constitutionally to a bifurcated trial. Defense counsel brought up the Fifth Amendment issue and how that's different in the Massachusetts Constitution, but the SJC has already made it clear that when defense counsel and defendant choose to have the defendant interviewed by a psychiatrist and raise these issues and interviewed about the event, that they're waiving their Fifth Amendment privilege. So that doesn't come into play any longer once that's done. And that's been done here, and the intent here, as in Blaisdell, is to present that to a jury. The second issue is that the 2 trials would be nearly identical. Defense counsel has stated that certain witnesses might not be called, such as EMTs who come in and see the bodies of these 3 little kids on the floor in the basement. But Commonwealth argues that would be admissible evidence in the criminal responsibility portion, because it does go to mens rea. It goes to what she did, how she did it, why she did it, what her thought process was during that, how she planned to do that, and how much time she needed to do that. So these would basically be 2 identical trials, just like Commonwealth versus Scott from 1990 states that the evidence of a lack of criminal responsibility was related to the mens rea component of the crime itself as well. So you'd be having duplicate trials for no reason if we were to proceed in a bifurcated manner. Also, all of the case law that I have found has been in instances where the courts have repeatedly denied a bifurcated trial, and the appeals court and the SJC have repeatedly upheld those decisions. And in his motion, defense counsel did not cite any reason whatsoever to make this case different than any other cases that have been heard in this county or elsewhere in the state, and cited no case law to support this request. So I'd ask that you deny the motion for those reasons.
All right, anything further? All right. I'm going to take this under advisement, which is I want to go back. I read through all those cases. I want to go back and read through, considering the arguments of counsel. So I'm going to take that matter under advisement but I'll get that decision out as soon as I can, because depending on what the decision is, might weigh in on the trial schedule and things like that. So I'll get that out as soon as I can. Is there anything else?
Your Honor, there had been defense counsel's motion to record the forensic interview. We've come to a stipulation regarding that. The parties have agreed that the interviews of the defendant would be recorded in the manner proposed in defense counsel's motion. However, the testing portions will not be recorded. Defense counsel has signed for his client today. We plan on providing defense counsel with another copy so that the client can sign it herself, but we could submit this as a placeholder to the court, or would you prefer we wait?
Well, my thought is probably.
Look at Lindsay. Dead eyes. I mean, she's just dead inside. She doesn't want to live. She doesn't want to live. And her attorney has said that in court. I'm not saying anything nobody has heard before. Look at the Commonwealth stipulating to something. Wow. Allowing them to record the forensic interview. Shocking. Shocking. Right. Right. Another great example of the difference between Ohio and Massachusetts is that Ruth Miller, in the last 6 months since she murdered her 4-year-old son, has been evaluated by 3 separate forensic psychiatrists, one appointed by the judge, one appointed by the state, and her own. And Memory D says, see how quickly Ohio was able to have a psychiatrist evaluate the person. The fact that Massachusetts hasn't even evaluated her right now is very telling on their concerns for her mental health. Right? They just want to win, says Robin. They just want to win. There we go.
Probably good to have it in the file, then I can look at it and review it in regards to that. But and so, Mr. Reddington, if you get that when Ms. Clancy has an opportunity to sign it, that's fine. But I have that. I accept your presentation that you've gone over that with her.
Yes.
So
okay. Thank you.
Now, so the date, if I remember, sometime in April, wasn't it? The evaluation.
Yes, Your Honor. April 10th, 11th, and 12th.
Right. And I know that we have dates at this point: June 18th, July 13th, and then trial date July 20th. Correct?
Yes.
Does it make sense to maybe pick a date, maybe towards the end of April, after the evaluation, just in case any issues kind of come up that we need to deal with in regards to that? I just, things happen sometimes. So it just kind of be a good idea to kind of touch base with everybody.
Yes, Your Honor.
Mr. Reddington?
Yes.
Or where you're going to be sitting, Judge.
Do it here. I'm going to be in Denham, but I can come here. It's probably easier for me to come over here.
Maybe Friday the 24th of April?
I'm available.
I'm supposed to be in Dedham at 2 o'clock in the afternoon, and I also, somebody put in my calendar, New York Yankees and Houston Astros. I don't know what that's all about. I think it might be the secretary, but I could not be here unless I continue the matter in Dedham.
I think he just outed himself as a Yankee fan. I'm sorry, what? Yankees versus Astros in your calendar? I think he just outed himself.
Which I can certainly reach out and try to do. It's a motion to suppress.
We have flexibility, Mr. Reddington. How about the 1st of May, which is the week following? That's a Friday as well.
I'm available.
The Friday, right?
Yes.
It is.
I got to be in time again. I got to be in Dedham on another matter. Motion to suppress.
Thursday the 30th or Thursday the 23rd?
And this would be at 2?
2.
I could do the 23rd. I'm not available the 30th.
I can do the 30th, not the 23rd. Wait a minute. Let me check one thing on the 23rd.
Maybe if we went back
So I could.
Friday before that.
Wait a minute. Hold on.
17th.
The 23rd, I have to be in Barnstable in the morning, but I could be here in the afternoon.
All right, does that work?
Yes.
All right. And that's for status regarding the evaluation and any other discovery issues that might
Yes.
come up as a result of that.
Good.
All right. Anything else we need to address?
No, Your Honor.
No, thank you.
All right. So thank you very much, Ms. Clancy. Thank you.
Now,
We're not going to Corey Richens because we're not covering Corey Richens because everybody else is covering Corey Richens. And maybe I should have covered Corey Richens because everybody else seems to be interested in it. So I think a lot of people jumped to go watch Corey Richens' trial. And it's a good thing that this didn't conflict because this started early and the Corey Richens trial, which is in Park City, Utah, one of my favorite places in the world. They're on Mountain Time. So they start at 10:30, I think, Eastern. Thoughts, questions, comments, concern. Nate Taylor says maybe after clarity will set in after treatment. You mean for Ruth Miller? I don't know. Thank you, Kels, for your super sticker from across the pond. And Mitchell says, I don't trust a juror not smart enough to get out of jury duty. Listen, Mitchell, everyone should serve on a jury. Good jurors are important. I don't think everyone should be trying to get out of jury duty. It is a very, very important public service. Defendants need good jurors, and you folks are good jurors because you understand reasonable doubt. You understand the burden of the state. You understand the basics of what being a good juror is. And so I respectfully disagree with you, Mitchell. And I think that everyone, if given the opportunity, you should serve. It is one of the most important rights that we have in this country is the right to a jury trial. And please do it. Please do it. Michelle said, I got put on meds years ago for stress and to help quit smoking. Apparently, I turned into a different person. Were you on Chantix? I know so many people that took Chantix that really went nuts. She says, luckily, my family stepped in after a couple of months and got me off. I've been fine ever since. Yeah, Chantix has wild side effects from what I hear. Like people became enraged. And I know a lawyer who was on Chantix and he had a fist fight with another lawyer in the hallway of the courthouse just because of that. Chantix made him nuts. Memory said, I work full time. I have had 3 small children. And I love being on jury duty. Scott McGinnis says, Reddington is all over the place in Massachusetts trial court. He's always in high demand, seemingly omnipresent. Yes. Tracy Dan has not watched any of the Corey Richens trial. I feel like we're the only ones not watching it. Try and give you a Corey Richens alternative, but it seems like there's not a lot of interest. Jenna says the Corey trial is boring. And I love sarcasm, says the real ones are still here. Emily Baker, and I love Emily Baker. She was going until 9 p.m., past 9 p.m. Eastern last night. Does that judge in the Corey Richens trial work until like 7 p.m.? It's crazy. Oh, that's crazy. Nay said, my niece testified in the Corey trial. I didn't even know till yesterday she works for the coroner. The judge is awesome on the Corey Richens trial. There is a case that is coming up. Oh, Mitchell says that he was just joking. Okay. He was on it. He was 3 times on it. He was on a jury 3 times. Emily starts late, but then she zips through everything and then sometimes she gets to real time, right? So what time does that judge work until? Because even 5 p.m. Mountain would be 7 p.m. Eastern. I stop a lot too, right? Bridget says they don't have enough good evidence in the Richens trial. Really? I thought she was slam dunk guilty. Do you think there's a chance she's going to be found not guilty? Aaron Spencer's standing for sheriff today. Wait, it's today. You mean today is the primary in Arkansas? Recovery Attic was on until 6. And he covers it real time, right? And so 6 p.m. Eastern. I don't know what time zone you're in, Mac RN. Today is election day for the sheriff, or it's the primary? Hold on. Hold, please. Let me go to the Facebook page and find out. I mean, do you think that he's going to win? I thought it was a primary for some reason. But election day is in November? Not for the sheriff? I don't know. Hold on. Hold, please. We can talk about whatever you want. Choose your own adventure, folks. Choose your own adventure. I had a whole thing set up for you guys yesterday, and I never got around to coming on the air because that trial was going on forever. And who wants to talk about the SAG Awards fashion? It was so much harder for me to pick best dress than it was worst dress, by the way. All right, let's see. Aaron Spencer. Where's the Aaron Spencer for sheriff page? Wow, we support Aaron Spencer page has 75,000 followers. That's awesome. Aaron Spencer for sheriff. Let's see. It is election day. Today's election day in Lonoke County, Arkansas. Oh man, when are we going to find out? Voting goes until 7:30 p.m. Oh, well, I mean, should we watch this? Should we watch Aaron Spencer's interview that he did about his campaign for sheriff? To the point where I needed to go to the Aaron Spencer page to find this. Let's do it. Let's watch his. Okay, for those of you who don't know, is there anybody here who doesn't know anything about Aaron Spencer? Aaron Spencer is a father. He's a combat veteran. His 14-year-old daughter was graped by a man named Michael Fossler many times, apparently groomed and graped by a man named Michael Fossler. Michael Fossler was 67 years old. Aaron Spencer's daughter was 14, I believe, when she started being groomed and graped by this man. Luckily, because if you know anything about child SA, luckily the parents found out or the daughter disclosed within a month of these events. Parents pressed charges, went to Lonoke County Sheriff's office and pressed charges against this man, Michael Fossler, 67, who happened to be previously a police chief in Indiana. You got that right. Where some other victims have come out of this Michael Fossler. One night in October 2024. No, was it 2025 or 2024? Remind me. Aaron Spencer wakes up in the middle of the night. His wife wakes up. The dog is barking. They go into the daughter's room. She's gone. Oh, I forgot to tell you the part where Michael Fossler got arrested and charged with something like 44 felonies of CSAM and SA against his daughter, and then was let out on bail for $2,500 by a judge by the name of Barbara Elmore, who has a history of doing that, which enabled him to then kidnap her and grape her some more. And so Aaron Spencer goes out to look for his daughter, and he happens to find Michael Fossler driving his truck with his daughter in the passenger seat. A chase ensues, let's just say. Michael Fossler's truck is run off the road, and he's trying to hold the daughter back from going with her dad. And let's just say that Aaron Spencer does what any good father would do, maybe, perhaps, and pumps the guy full of lead. The wife had called 911 to say, listen, we have a restraining order against this guy, Michael Fossler. We think maybe he has our daughter. And they're like, okay. And then Aaron Spencer called the police, I'm summarizing, and said, hey, remember that guy we called you about that we thought had our daughter? Well, he did. I found her, and you might want to come and check on his condition. Since that time, they indicted Aaron Spencer on murder charges, and guess who the judge was that was handling his case? Barbara Elmore, the same judge who had let Michael Fossler out on bail, because you just can't make it up, right? Within 10 days of Aaron Spencer's arrest, his family was a little verbal, let's say, on Facebook and other modes of social communication. And within 10 days, Judge Elmore slapped down a gag order, which went all the way up to the Arkansas Supreme Court. They found it to be unconstitutional and even said Barbara Elmore should not be handling this case. And she overstepped her authority. It's not constitutional. Many other things have happened, including, I don't know, put some in the chat. But eventually it went again to the Arkansas Supreme Court, I believe, and Elmore was removed from the case. A new judge has been assigned, and I don't think there's a new trial date yet. But during all of this, Aaron Spencer decided he is going to run for sheriff of Lonoke County because he thinks that the people of Lonoke County should be entitled to a sheriff who actually knows what the F he's doing, and that it's a fair system for Aaron Spencer. Today is election day in Lonoke County, Arkansas, and apparently he did a couple of days ago. Aaron Spencer did an interview with this Conduit News. And so we're here. Might as well watch it.
The Lonoke County Sheriff's race has drawn national attention as candidate Aaron Spencer campaigns while awaiting trial on a second-degree murder charge that's tied to the 2024 shooting of a man he says he found with his missing daughter. Aaron Spencer joins us today on Conduit to talk about his campaign.
Wait a second. That was not in 2022, was it? Hold on. I don't think it was, but I'm going to check my dates.
As candidate Aaron Spencer. The Lonoke County Sheriff's race has drawn national attention as candidate Aaron Spencer campaigns while awaiting trial on a second-degree murder charge that's tied to the 2024 shooting of a man he says he found with his missing daughter.
Right.
Aaron Spencer joins us today on Conduit to talk about his campaign and while he's focused on accountability, child protection, and restoring trust there in Lonoke County. Aaron, thank you so much for joining us on Conduit. I know that right now, with just a few days left in your campaign, there's a lot going on. But I know that our viewers would love to hear from you. So first, just tell us a little bit about yourself and how long you've lived there in Lonoke County and your family and that sort of thing.
Well, thank you so much for having me. Yeah, I moved to Arkansas in 2012 after I got out of the military. I did 4 years with the 82nd Airborne down in Fort Bragg. And after that, I got out, became a judicial marshal for the state of Connecticut. And the wife and I decided that we were going to raise our children in Arkansas because that's where she's from. And so we moved down here in 2012 to Ward, and I got into construction and then transferred over to doing management at Central Laundry Equipment right here out of our own county. I was there for about 6 years where I did their parts and service department, helped revamp the parts department with inventory, helped implement a new computer system for inventory tracking, as well as service records and our service technicians. And from there, we decided that we were going to move down to Florida for a few years because my wife had a new job opportunity.
Okay.
And we got down there, and that was right around the time of COVID. And so we ended up buying a 10-acre farm and decided to get into homesteading.
Awesome.
And so we did that, and until her father became a little more ill than he was when we left. And so we decided to go ahead and sell the farm, move back here to Arkansas and take care of him while he was on hospice. And that kind of brings us to here where we're at now. So
Yeah. Mentioning that you moved to Florida during COVID, that was probably like the best state that you guys could have moved to.
Yes.
During that
very
time.
Beneficial. Yeah, very beneficial. Yeah.
Well, as I mentioned in the intro, you are facing you're facing a second-degree murder charge there in Lonoke County. I know so many people here in Arkansas and really across the country are very familiar with what you and your family are going through right now. I also know that you can't talk that much about it, but just walk us through the events that led up to that charge. And also, too, you're awaiting a trial date while also running for county sheriff there. Talk to us about that.
Well, the events in 2024 were very tragic of what happened to our daughter, to our family. And, you know, at the end of the day, I did what any good father would do to protect myself and my child. And, you know, we were really hoping to have the trial over with before the primary elections, but you know, we saw a lot of inconsistencies and lack of transparency with what was going on with that trial. And so, you know, we filed some motions on behalf of ourselves and the rest of the people of Arkansas to make sure that everyone's constitutional rights are upheld. And, you know, the Supreme Court judged on that. And, you know, they decided that there was a massive amount of lack of transparency. And so, you know, they removed the judge from the case, and we have a hearing coming up in March to set a new trial date. You know, from the beginning, that's all we wanted was a transparent trial, you know.
A hearing coming up in March. I wonder if that'll be televised, because there's a new judge now. Judge Elmore did not allow anything to be televised. Everything was done in secret. A lot of records were sealed. And so we'll find out when this March hearing is, and hopefully the new judge is going to allow some cameras in the courtroom, because we really, really, really want to see what happens in the Aaron Spencer trial. Interestingly enough, the New York Times picked this up yesterday, it looks like. Interesting article. He is charged with murder. He could become a sheriff. And apparently Aaron Spencer did not return the New York Times call for a request to comment, which is interesting. If he is elected sheriff today, because today's election day, if he is elected sheriff and then he is found guilty, he will have to give up the sheriff's position. So let's see what happens. We'll have to see what happens with that. He saved his daughter's life. I agree, Melissa. I don't think his daughter was coming home alive that night. I do not think so. This was in October 2024. And here we go.
And so I'm confident that that's what we'll get. I'm also very confident in my legal defense. We have a great team working on this. So, you know, I'm excited to see what the outcome is, and I would definitely implore all people to come to my trial and see it for themselves.
Whenever you decided to run for county sheriff, was it something that you thought about before 2024, or once you really, you know, kind of saw the underbelly of everything that was happening and what your family was going through there in Lonoke County? Is that what prompted you to decide to jump in and try to course correct things there?
Well, yeah, you know, I never had any aspirations to run for a public office. I was very content with my life that we have built here with our family, you know, raising birds and breeding livestock, guardian dogs, you know. I have a wood shop. And so, you know, we try to be as self-sufficient as possible. I've been actually for years trying to get as much out of the spotlight or off the grid, as you would say, you know. But it was definitely I would say that would be the catalyst to why I decided to run for sheriff. Was not just with my case, you know, that gave me a very deep inside look of how investigations are done, how the sheriff's department is ran. And it's not just the sheriff's department, you know, this is a systematic issue that we're having here in Lonoke County. You know, we have issues in our judicial system. We have issues with the bond schedule. We have, there's a lot of stuff going on here. And during that time of working through my case, we've had roughly 80 or so people reach out to us, and they have shared their own cases, their own in-runs with with law enforcement here. And the stories that I've heard are quite tragic. You know, and it's not necessarily that it's not a deputy problem, it's a leadership problem that we're having here. I think there's a lot of complacency. I think there's a lot of lack of transparency. There's a lot of policy violations. So it's just, you know, we have everything from bad investigations going on to massive issues in the jail. You know, it's once something happens, the Band-Aid kind of gets ripped off and people are like, you know what, that's it, I've had it. You know, here's.
Ooh, remember the lawsuit that we read about the lawsuit that was filed against the jail and all the women that were being abused in that prison, sexually and otherwise? Yeah, they got a lot of problems in that county.
Here's my story. This is what's happened. You know, here's my documentation.
Wow.
You know, so we've seen a lot that's going on there. The jail is very concerning to me. Was very concerning to me.
Talk to us about that. Why?
Well, over the last few years, we've had multiple female inmates sexually assaulted in the jail. We've had inmates assaulted. Everybody's seen the video of our current sheriff who was assaulted an inmate and lied about it. So, you know, I think that if you.
Yep, say his name, Mickey Steins. Mickey Steins is the current sheriff. A lot of problems in that office.
You can't hold yourself accountable and you're going to lie to the public, you know, you don't deserve to be in that position. But more so over in that jail, you know, the conditions are filthy and we have females being assaulted. And this is not inmate on inmate. This is staff assaulting the inmates.
Yep.
We get reports all the time that the females don't have proper feminine hygiene products. You know, we have reports of people bringing in contraband. You know, you can't stop everything in a jail, and I understand that, but no woman should worry about being sexually assaulted by staff members, right? Even if you still have constitutional rights.
Sorry, that's right. Mickey Steins is not the Lonoke County Sheriff. What the hell is his name again? Why did somebody put that in that's the one from Kentucky. Why did somebody put that in the chat? What the hell is his name, this guy? Hold on. Took me a while to catch up on the chat. It's not in the near. Oh, Staley, Sheriff Staley. Sheriff Staley, that's his name. It's not this. Forget it. Sheriff Staley has been also accused of, I think there's even video of him beating up an inmate or something. Thank you, Elaine. My brain is all over everywhere. John Staley. Right. It's the, that's who the lawsuit is against. They've been graping and essaying the women prisoners. Go back to one of my prior, sorry about that. My brain is mush. One of my prior streams on Aaron Spencer for that lawsuit. It's an interesting read.
Detention. And it is the staff that is supposed to help uphold those. There's not reports going to for PREA violations. You know, it's just they try to keep everything internal. So it's just, you know, there's a lot of safety issues there. So I think we need to make some big changes within our jail.
It's interesting to hear you talk about the jail, and you know, unfortunately, there are instances like that all over the state right now where it's just a systemic problem. And it's, you know, and like you said, it's with the leadership, you know, cutting off the head of that snake. And that's really the only way that you can change things for the better. And also you said that you tried to get even more off the grid and off the radar, but you had to jump in. And that's also something that we're hearing from a lot of people right now. People who, you know, are running for office and they're like, I didn't want to do it, but I had to for my family, for my kids, for my friends, and for my county. That's up here in Washington County. You hear candidates who are like, I don't even want to be a politician. I just want to get in there and serve, you know, do a few years, help, you know, every way that I can, and then move on and get back to my life.
Absolutely.
Are you like, is that what you're seeing too?
Well, absolutely. I mean, you know, I'm a combat veteran, and, you know, I definitely take it very seriously of the oath that I took to uphold the Constitution. You know, and that was against all enemies, foreign and domestic. And right now we're having a domestic issue within our county that needs to be addressed. I can't sit idly by. I have too much integrity for that. You know, I've weighed the costs of what it is going to be to run for office, to hold that position if I'm elected, and it's a lot. You know, this is no easy task on myself or my family. We have a lot going on, as we discussed, and so this doesn't make anything any easier. But I, for one, will not stand idly by and allow this to continue. My neighbors, they deserve better. Our children, they deserve better. And, when it comes to our children, they are our future. We have to be able to protect them. The sheriff needs to be advocating to the prosecutor and to the judge that we need to reform our bail schedule that they use here in Lonoke County. I've been saying it for the last few months. If you commit a crime against a child, it's just the cost of a lawnmower to get out. And it's appalling. It's absolutely appalling. So I understand the sheriff doesn't have direct control over bail, but what he does have direct control over is the investigations. And if you're not doing investigations properly and you're losing evidence and you're not filling out your reports properly, how's the prosecutor supposed to prosecute these individuals? So we kind of have a failure all the way around. And it would appear that it's a lot of it seems like a high school clique around here. It's like the good old boy system. Everybody's doing favors for everybody else to keep their name looking good on paper. I'm sick of that. Like, I wasn't born here, so I didn't go to high school with these guys. I don't owe them anything. I don't owe any favors, so I think that, that's one of the reasons that makes me a good candidate, right? Is because I'm not beholden to the ones that are in charge right now because of my past, right? I'm here for the future of my county, so.
What do you say to those who, and voters, and I do want to hear the feedback that you've gotten whenever you're going around Lonoke County, but how do you, or what's the response whenever they meet you and they talk to you and you're asking for their vote and you're telling them about yourself, and then, you have this, you're awaiting trial, but then you're also running for office. How do you explain that to voters and then also ensure, or I guess, reassure them that you're the right person for this job?
Well, I will be honest with you. Nobody actually brings up my case. It's like they don't even see it. Like they don't even care. I mean, they hint on it, but it's not a reservation for them. You know what I mean? I think the people here have been able to see, people are really involved with my case. And there is a lot of public record and document that has been put out through different motions and filings from the prosecutor's office and our legal team. And people are really following it close. And so I think they fully understand I can't talk about it. And I've told people who have brought it up, look, I have to show integrity. I want to protect the integrity of the case. This is obviously, we're in a campaign for running for office right now, but I'm not even going to talk about the case because we need to show good integrity with that, But it definitely doesn't bother people. I haven't had anybody come up to me and talk to me that and tell me that it's a reservation for them at all.
Good. What would be?
Yes, Linda Lane. The same thing was going on with the inmates in the Kentucky jail that Mickey Steins worked at with the women's inmates. Right. Now you can see why I'm conflating my cases.
Your top priorities, should you get in office? We talked about a lot. There's a lot of systemic issues there, but in those first, 90 days, let's say, what would you really want to focus on?
Well, probably in the first 90 days, we can start with unlocking the front door of the sheriff's department. That's been locked for quite a few years.
It has?
Yeah, you got to go to the front door. You got to ring a buzzer. They talk through you through a mic, and then somebody from one of the clerks or something like that, they'll come out and give you what you need, whether it's documentation or whatever.
What's the purpose? What's the reason? I don't think that's standard. So what's the reason for that?
Honestly, I don't know. I heard that it started sometime around 2021. It just seems like it's a barrier between the public and the sheriff's department, which again shows a lack of transparency. Just like the social media comments, if you have a social media account for the sheriff's department that's being paid for to be ran by the taxpayers, why not turn the comments back on? There's no reason that we need to hinder people's free speech just because we don't like the comments. I think we are all adults and we can engage how we see fit. And obviously we would, if there was some type of threats made on there, right? As law enforcement, we investigate those, but we can't just turn off the comments to the public on a public platform that they are paying for because we don't like what they have to say. So I say unlock the front doors, turn the comments back on, and then let's go ahead and start doing a deep dive into the budget. I've looked at the general version of the budget. seems okay when you skim across it. Not any major red flags, but there's definitely places where we can save money. There's definitely places where we could utilize more of the money that's there. You know, right now the sheriff is stating that he is fiscally responsible with our tax dollars. Well, we had a I think it was 0.5% increase a few years back, which doubled the sheriff's department budget. Went from somewhere around 4.6 million to it's almost 9 million this year.
Okay, we're only about halfway through this, but I want to break to the verdict in the Colin Gray trial. If you want to watch the rest of that interview, go over to Facebook and check it out. But the verdict came in on the Colin Gray trial. He's the father of the school shooter. First ever father to be tried for murder. Let's watch it. It's 4 minutes long. And then that way you don't have to leave. All right. Go back to, if you want to watch the rest of that, it's on the Aaron Spencer for Lonoke County Sheriff page, and it's the Conduit News interview, which is like the second thing down. But let's listen to the judge read the verdict in the Colin Gray trial. This is interesting. And here we go. Did any of you watch the trial? After the Crumbly trials, I could not handle covering another parent of school shooter trial.
Any objections to the form or legality of the verdict?
Not from the state, Your Honor.
No spoilers, please. Please don't spoil it for those who have not seen the breaking news yet. Thank you so much.
Ms. Jones, if you will publish the verdict.
In the Superior Court of Barrow County, State of Georgia versus Colin Gray, case number 24-CR-593-P, jury verdict. Count 1, murder in the second degree. We, the jury, find the defendant guilty. Count 2, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 3, murder in the second degree. We, the jury, find the defendant guilty. Count 4, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 5, involuntary manslaughter, unfaithful act. We, the jury, find the defendant guilty. Count 6, reckless conduct. We, the jury, find the defendant guilty. Count 7, involuntary manslaughter.
The father doesn't look surprised at all. He's got like zero reaction. He looks annoyed, actually.
Lawful act. We, the jury, find the defendant guilty. Count 8, reckless conduct. We, the jury, find the defendant guilty. Count 10, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 11, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 12, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 13, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 14, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 15, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 16, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 17, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 18, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 19, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 20, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 22, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 23, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 24, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 25, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 26, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 27, reckless conduct. We, the jury, find the defendant guilty. Count 28, reckless conduct. We, the jury, find the defendant guilty. Count 29, reckless conduct. We, the jury, find the defendant guilty. This third day of March 2026, signed for person.
So that's that. He was found guilty of all charges. I think somebody said there were 27 charges. He had bought his son an assault weapon for Christmas, I think, right? It's going to affect a lot of cases going forward in other states. This was in Georgia. I think did you guys say there were 27 counts? I didn't watch it, so I can't really opine, but you guys can give me your thoughts if you did. Such as that it was a hunting rifle. I thought it was like was it an assault weapon or a hunting rifle? See, I don't even know. Different states have different gun laws. The son has not been on trial yet. This trial came first. This trial came before the son's trial. And the son, I don't know how old he was. How old was the son when this happened? 14 or something? Tell me. No, but he bought his son the gun. And apparently people are saying there were more red flags with this son than there were in the Crumbly case. Thanks, Mallory. It was an AR style weapon, right? It wasn't a hunting rifle. Right, Becky says, who buys their child an AR? Asking for a friend. Crazy for Disney says, this school's 3 miles from my house. That's scary as hell. Law and Disorder said, I thought 29 charges since they added the lesser included. I don't know. And thank you for chiming in because I didn't watch it. And these kind of cases outrage me. My children have been undergoing school shooter drills since they were in kindergarten, and they have nightmares about school shootings. And so a little too close to home for me. He was 14 at the time he was. Okay, so I got that right. Yeah. He and his son were visited by law enforcement before the shooting, says Mary. Okay. All right. DM Cake Lady says AR does not stand for an assault rifle, FYI. All right. Well, I don't know how to feel about that. Chronically Annoyed said, anything new about Karen's phone? Yeah, a lot of misreporting. That's what's new. A lot of people on the cesspool over there and other social media were reporting yesterday that the O'Keefe's request for an emergency TRO against Karen was granted. It was not. It was denied. So I don't know why everyone's spreading the wrong misinformation, but the request by the O'Keefe's for a temporary restraining order from Karen getting her phone back was denied. I can go over that later if you want me to. Let me know, and let me know what time is good, because everyone's watching the Corey Bishop's trial right now. What happened was the judge said, no, I'm not going to try and prevent Judge Doolin from returning Karen's phone to her. But if she does get her phone back, she's ordered to preserve it. And there's already a preservation order in that case anyway. So I don't know why everyone out there is reporting that it was granted, because it hasn't been granted. We can talk about that later if you want, maybe like at nighttime. Tell me what time you want to do it. But also, Aiden Carney's phone extraction is being published all over the cesspool of Twitter as well, or select messages are anyway. And I will point out to you that some people who are selectively posting text messages of Turtle Boy, aka Aiden Carney, are failing to redact the cell phone numbers of people like David Yannetti. Really? Will there be ramifications for that kind of behavior, like putting David Yannetti's cell phone number out there? I don't know. Probably not. Massachusetts, is selectively persecuting their laws. And so we still don't know if Judge Doolin who's hearing that, returning the phone motion. I can't keep it straight over there either. There's so many judges, so many motions. I don't think he's decided whether or not she's going to get her phone back, but the judge in Plymouth Superior was like, I'm not going to stop that from happening. So I don't know why people are saying that it was granted, because it hasn't been granted. No, it hasn't. It is Doolin, right? See? Thanks, Dobie Mama. And, well, she says, I don't believe anything unless it's on this channel or Turtle Boy. So I think I'll set that up for later. But again, if this Corey Richards trial goes until 9 p.m., like, what's the good time to do it? Life I Live For Now says, I'm relieved to hear other people are still so affected by FOST, still need to get the word out regarding the injustice done and raise money for the appeal. It's so true. So much chaos still, I know. Diane Gallagher says, I love your candor and corrections of all things happening in the cesspools of social media. I know. I mean, what is like, it's so weird. I don't know. I don't know. I don't get it. But what I see or what I hear and what I'm picking up is that there is this flurry of activity, right? Consistently when something very damaging comes out about the McCabe's or the Alberts, right? And then there's this flurry of activity to try and point fingers at Turtle Boy and, whoever else. Turtle Boy. Like, yeah, they're doing it on purpose. It's wild. It's like marching orders. It's like, I don't know what's going on over there, but it's bizarre. And it's obvious. It's obvious. Tell me if you think it's obvious. No house, no Faust. JoJo said she watched with the defense diaries and the jury came back quickly. How long are they out for? Didn't they just get the case yesterday? I want. Today's Tuesday. Yesterday was Monday. Corey Richards, I think, is going to be going on for weeks still, right? Scott doesn't have any interest in that. No house, no Faust. Yeah, people love to be first to post the latest news. Andrea says that anything that's been released from Aiden's phone is a huge nothing burger. I Love Dog says it's extremely obvious. And in Lemonade says the same. It's obvious and totally New England style. Tell me this. Is this turning you off to the whole Karen Reed debacle? Rebecca says 5150 needs to be arrested. I think she's referring to ex-girlfriend of Aiden Carney, Meredith. She's claiming she's not the one who released it. He's claiming she's the only one who had access to it. Kate Peter, Mafia Massel, is saying that's not who gave it to her, but it's been distributed to everybody from the the Haas defendants YouTube channel. And they're all printing David Unetti's cell phone number out there without abandon. Right? It's crazy. Michelle says, it got so confusing with everything about Turtle Boy and his texts. I just had to scroll past it. I couldn't make sense of any of it. I tried to support him, but I can't understand it all. I don't know. Do you feel like people are requiring you to pick sides against either Karen Reed or Turtle Boy? Do you feel like people are trying to get you to pick sides? Because there was recently another fundraiser held on that Calling All Beings channel, and Alan Jackson showed up for it. Did you guys see that? I saw like maybe 2 minutes of it. Alan Jackson showed up for this fundraiser. As soon as Alan Jackson showed up, they started bringing up all the other people on the Brady Bunch channel. It was as if they didn't really give him a chance to talk. And so he was on panel with a bunch of other people, including Nick Rocco was on there, and Lana from Truth and Transparency was on there, and she is very vocal about the fact that she thinks Aiden Carney belongs in prison. As are some of the other people on the panel. Yes, Mariam, we did talk about that. Justin, it for the money. Alayan's partners in crime, her brother and 2 firefighter friends. Yeah, we did talk about that. And so, Kippy Hippie says, it's turning me off. I love sarcasm, says what I watched was on the Glarer. Kathy says, there's no reason to pick sides. They are both fighting for our rights. Diane says, I will not pick sides. Both deserve our support. I mean, Lori says 5 more weeks for Corey's trial. Sunset Seeker says, I still can't believe they aren't prosecuting Justin in the Kelsey case. That could change. It could change. There's a lot of public outcry on that. I mean, after the ADA got up in court and said, oh, well, Judge, I put a whole Instagram reel out about it, and I put a short on YouTube. They haven't even spoken to Justin, and they decided they're not going to charge him. And he actually said in open court, Gubitosi did, I will, Judge, if he testifies and decides he needs to take the 5th, then of course we're going to immunize him. They're going to give him immunity. What? They haven't even spoken to him. It's wild. It's insane. It's crazy. Robbins says, give AJ at least half the screen. Come on. And he was only on there for maybe 15 or 20 minutes, right? Oh, I heard that about the select board meeting. I haven't had a chance to watch it yet. Sarah Grace Patrick's trial is in August. Melissa said, and AJ being there was such a waste of his time, and they had less than 300 on when AJ was on. Such a disaster. I didn't watch it, but I wanted to get your thoughts on it. Sounds of Serenity says, absolutely feel the pressure to pick sides and still picking Turtle Boy. Aiden, he clearly has a target on his back, and it doesn't matter why. Ms. Holmes says that at 51 is an effing liar. She had access to all of it from Aiden's phone, gave the extractions to Kate Peter, and she's not denying any of it. Kate Peter is loud and proud about publishing Aiden's phone. I mean, is it a distraction? Oh, no, don't look at Proctor's phone extraction. Look over here. Look over here. Pazlou says some of these people should find another way to try and stay relevant. I Love Sarcasm says, I do not understand their marketing. Why would you not promote Alan Jackson being on the fundraiser ahead of time? Scott McGinnis, boots on the ground, says, I steadfastly support both Karen and Aiden. Now I'm in some weird no man's land. I lost 7 wrenches in the X's and the YouTube wars so far. You're modding for 7 different channels? Melissa says it's gone way too far. Lori says, I really think that Turtle Boy is really trying to protect Karen on his phone part and her lawyers. I do feel bad for him. Song B. Annie says, I'm sticking to siding with facts. The drama I don't bother with. I feel like it's the same 20 people all the time who keep regurgitating the same stuff over and over and over. And there's several of them who also have other accounts that they post under. And so it just feels like there's a lot more person, right? Sherilyn. Hi, Sherilyn. She says, yeah, if something goes on in the McAlbert sleeper cells come to life everywhere, right? And it's like, look over here, look over here. I don't know. I don't know what's real anymore. I don't know what to believe anymore. But it gives Ms. Nomer so much anxiety. Becky says, they're lost, Scott Messerschmidt. I mean, they're Scott McGinnis. Naughty Dog says, if the truth of the matter is, if he didn't do what he did and stood up and stood out, I do not think that she would be free now. I mean, can we all agree on that? Do you agree with that? I can't keep up anymore either. Right. Crowtastical says Gubitosi didn't even try and hide his misogyny. Memory says DA just literally took the cop's word for it that they gave him permission to go in and did not look into any of the other allegations presented to him. I don't even think he spoke to the police either. I don't think he spoke to anybody. 25 years on the job. Says only one lady spoke out at that select board meeting in North Andover. What does that tell you? Two people spoke up during public comments, and one lady brought up just in it for the money. That's it, just one. Ms. Holmes's opinion is, I don't know why Karen Reed, the Roccos, and Alan Jackson even bother showing up for Young Jerks, Truth and Transparency, Brian LTL, JFK, or James Jackson. They all pushed the movement dividing. I mean, I feel like, I don't even know what I feel like anymore. I feel like it's turning a lot of people off, and you can let me know if you feel that it's turning you off. And I really want to take your pulse on that, because it's just interesting to me that Karen would choose to align herself with those particular people. And I don't know if she knows what's going on, because if Nick Rocco is speaking for her, he's saying that she doesn't know who was going to be on what fundraiser, and she doesn't know anything that's going on. And listen, we know Karen Reed knows more about her own case than anybody, than her attorneys, than anyone. And so I just find that a little bit hard to believe. Rebecca says, yes, we're numb. Kraft Haskell says they're losing donations massively. They're turning Christie off. Kelly's all over all of the nonsense, or over it all, I think is what you meant to say, right? Elaine says, I've walked away from all the channels except yours. Thanks, Elaine. I try and stay out of it, and I don't really want to talk about it, but I'm curious about how it's affecting all of you. Because 80% of you say you don't engage on Twitter, but many of you do. And so Mitchell's turned off. Andrea, 100%. All the divide is doing is helping the McCabe's and Alberts. Distraction and building hate within. Right. Tamula says, no, I disagree. I heard about this case before I even heard about Turtle Boy, and I knew she was innocent too. I did too, and I screamed very loudly on YouTube. But before I ever started covering this, Aidan Carney had been covering this for a long time, and he wrote so many stories about it and blogs about it. And I just don't think that enough people, or as many people, I guess, would have known about it without his reporting. Right? I mean, when I covered the Edric Foss case, that is a case that deserved so much attention, and hardly anybody covered it, and it's over now. And now he's in prison for 2 life sentences plus 45 years, and the time to yell and scream about a case is before the person's incarcerated, right? Diane doesn't know what's going on, doesn't understand what's going on at all. Jeffrey said, once the drama started, my Karen Reed viewing went down to 0, except from the updates Melanie gives. It's childish. Thank you. Seems a lot of you are turned off. I'll go back and read the chat later, but I was curious. It's only about 1,500 of you here now, so. Cosgrove's Velcro Sneakers is here and says, I'm just glad I never dated 5150. All right, you guys, we're going to break for now. Make sure you have all your notifications set. Make sure that you hit the thumbs up button. Can't even think. Like the video, share the video, comment respectfully after the video. All of those things help the algorithm on days when Corey Richards is taking up most of everybody's times. All right. Stay cool, stay kind, stay classy. Thanks to the moderators. I love you with all my heart. I couldn't do this without you. I may be back later, so make sure you have your notifications set or just come back and check it out and let me know what time you want to do it. All right? Peace out, my friends. I'm going to see you real soon because if I don't see you soon, I'm going to die. I love you guys. Peace.